Someone make it make sense.
Probably a couple.
Hello, everybody, and welcome on in. Shout out to Flash being the first in the chat. So, alrighty, guys, we are here for part 4, but first we do have some new documents, so we're going to go over those real quick. Happy to see you in the chat, my friend. Also, everyone still continue to send your love and positive squirrel vibes to Super Planner Girl, aka Amanda, who is still healing from her surgery. We love you, Amanda, aka Super Planner Girl, aka Amanda. She'll always be Super Planner Girl, aka Amanda to me. So, all right, who's ready for some new docs, hot off the press or what have you? These just posted to the docket not that long ago. I did actually check it while I was at work and there wasn't anything new. And then lo and behold, here we go. So first up, we have the state's response to the defendant's 24th supplemental request for discovery. So comes now, state of Idaho, by and through Latah County prosecuting attorney and submits exhibit S1. Now, I've pointed this out before. Literally everything is S1. It's really funny. Like for months and months and months, you guys have noticed me say this. So I'm like, wait a second, S1, S1. Every different exhibit is labeled S1. It's a bit odd. And I kept saying to myself, they're going to get really confused when it comes to trial because everything is S1. It's bizarre to me. But anyway, we have another S1, a new S1. In response to the defendant's 24th supplemental request for discovery filed on June 25th, 2025, right before the plea, right? The defendant has entered admissions of guilt and is set for sentencing for July 23rd, 2025. However, in accordance with the Idaho Criminal Rule 16, the state has a continuing obligation to provide discovery. How many of you guys remember us talking about that on this channel, right? That between the phase of entering a plea and sentencing, that the state still has a duty to turn over discovery. We've talked about that a lot, probably on every live stream since the plea happened. That's in all of the rules. And sure enough, believe it or not, we have the state turning over more discovery. And I know Doug especially has brought this up a lot. And hopefully Doug will be hearing this either tonight or on Replay Crew, because sure enough, this 24th supplemental request for discovery has yielded some discovery being turned in after the plea, but before the sentencing, right? So that's the first filing. Next filing we have is, no surprise here, right? Motion to seal S1. State's response to defendant's 24th supplemental request for discovery. Now, what's interesting is normally there's not a whole lot of information in these, right? It's just like motion to seal pursuant to the rules. There's a little bit more information in this one than we usually get. So here's what it says. This motion is made on the grounds that the substance of Exhibit 1 contains information that would constitute an unwarranted invasion of personal privacy pursuant to the rules. For the named individual, that is the subject of each discovery request. Items 441 through 444. So there's 3 items, 4 items, I guess, if you count 441 itself. 4 items, 1, 2, 3, 4 of discovery. And it's pertaining to one particular individual, not plural, but one named individual, right? That is the subject of each discovery request. You know, at this juncture, we don't know who it is, obviously. Will we ever learn? Maybe someday. Hopefully some of this shit becomes unsealed. But there you go. Whatever it is, it seems like the defense thought it was still incumbent upon them to go ahead and make this plea or, make this plea offer before receiving this, right? Now, what's interesting is, like, technically speaking, a lot of people have talked about the timing of the plea deal, right? And I agree that it is interesting. Now, here's why. Because typically you would see these happen much earlier in a case, or you would see them happen much later. So a lot of people have said, why is it so late in the game? And to me, my response is like, I was surprised with the timing, because if you're going to make a plea on quote unquote the eve of trial, oftentimes they are on the eve of trial, quite literally, as in the day before. I've seen this in many, many, many cases. And in fact, the law firm I work for, this happens in many, many, many cases where it's literally the day before. So oftentimes you're seeing these deals made pretty early on, or maybe at a pivotal point, again, pretty early on in the case, or if they're posturing like they're headed towards trial, typically what you see is these pleas being made literally on the eve of trial, as in the night before. So it is interesting that the defense, they could have waited for this receipt of discovery from the state and whatever else is in the mix, right? Like, it's not like they needed to make that plea deal literally on July 1st or whatever. You know, they could have waited until the eve of trial. Now, why didn't they? I don't know. That is another mystery that I have been thinking about, but I think it's even more interesting considering that they've just been given more discovery pursuant to their request, and it seems to be dealing with a specific individual. So, I mean, ostensibly that individual could be Bryan Kohberger. It could be, or it could be somebody else. But nonetheless, it's odd that they didn't, again, A, wait for the return for discovery to come in, and B, again, like I was saying before, is still just odd in the first place that if you're going to make a plea deal this late in the game, you know, again, typically you see them on literally the eve of trial. So interesting things there. Where is everybody? I have no idea, Flash. I have no idea. Good question. There you go. Flash is saying there's a case in South Carolina where a plea was entered 15 minutes before opening statement. Yep. It happens. It literally happens. That is not out of the realm of that would be like more typical than like a plea deal a couple weeks before trial when it's been a case that's been ongoing for years. You know what I mean? So, okay. So then we have next up here, order denying. Oh, and by the way, as far as the motion to seal, that was granted. So there's nothing else interesting there. Then we have an order denying request to video the record sentencing, or video record sentencing proceedings and approving stool. So what this is saying is people were making motions or wanted to be able to video record it. And so what the court is saying is that a live stream of the sentencing proceedings will be provided by the court on its media streaming account, basically as we've seen this entire time, right? Therefore, the various requests by media to be present to video record the sentencing proceedings are denied. To ensure that quality images are available, the court will permit a pooled still photographer. And again, just like before with the plea, right? The Associated Press is going to be the one pool photographer, right? To then disseminate those pictures far and wide, or what have you. The permission to provide such coverage is contingent upon the AP agreeing to act as a pooled resource. Again, this is just like we saw before. As a pooled resource for such photographs, with all media requesting copies of any images taken in the courtroom. The photographer may only take photographs from the location within the courtroom assigned to them by court personnel. Photographs may not be published of any victims or members of any family members of victims. Photographs of the gallery and attorney work product, including any screens or papers a counsel table, may not be taken. Okay. I did send Twiz his special message. I did. Thank you for asking. I did send it. I actually remembered to send it this time, like right before I went live. So good for me. Yay. So there we go, guys. So those are the latest on the new docs. And now we're going to carry on where we left off with, let me just find where we were. Give me just a moment. It might take just a second to load. But we had left off with Roman numeral 3, I recall, in this legal article called Leveraging Death, which is, for anyone who hasn't seen it, this has been discussing the impact of the death penalty on plea negotiations and plea deals, right? And so this is the fourth part of our installment here, discussing the pros and cons of plea deals. And for anyone who hasn't seen it, you can always check out the other live streams, and they are all, as always, very much including detailed timestamps, as I am wont to do. So let me just find Roman numeral 3 here. Okay, so we need to go back further. Here it is, Roman numeral 3. Here's where we left off. And if Twiz joins us, maybe we'll get lucky and have another Twiz Reads session, because I know it's a fan favorite, Scroll Crew favorite. Flash ate a salad today. I am proud. That's awesome. We love salad. I love salad. All right, so here we are with Roman numeral 3, Georgia's death penalty. Prosecutors in Georgia have aggressively sought the death penalty since the practice first began in the colonies in 1608. Wow. Georgia ranks 5th in executions carried out since that time. Georgia also ranks 7th in the nation with respect to total executions since the death penalty was reinstated, and 9th in terms of its death row population. At the time of this writing, the most recent execution carried out in Georgia was that of Andrew Cook on February 21st, 2013. And I was actually just going to note that this article was from 2013. So Georgia has also been the most influential state in shaping death penalty policy, national death penalty policy in the modern era of capital punishment. No less than 17 cases originating in Georgia have set legal precedent with respect to the administration of capital punishment. Interesting, including Furman v. Georgia and Gregg v. Georgia, which respectively were responsible for placing and lifting the moratorium on executions in the United States in the 1970s. The following section provides a brief history of Georgia's current capital statute. I don't know that we need to know the history of the Georgia statute. I think we can skip past some of that and get to the more modern, because again, modern at this point, 2013 is still history to us at this juncture. But having said that, again, this was one of the more recent articles dealing with this issue. So, okay, with very few changes, Georgia's death penalty legislation has remained in place since Governor Jimmy Carter first signed it into law. However, there were several changes mandated by subsequent U.S. Supreme Court rulings. The year after the court officially reinstated Georgia's death penalty in Gregg, it invalidated the death penalty for defendants convicted of non-homicidal rape and kidnapping with bodily injury in respectively Kohberger v. Georgia and Eberhardt v. Georgia. So basically, in previous years, they could sentence for the death penalty, not just for murder, right? For example, like I said here, rape and kidnapping and whatnot that didn't result in a homicide was still eligible for the death penalty. And just for anyone who's not as up on these things, in the U.S. these days, right, whether it's federal or state, the only way to be eligible for the death penalty is for homicide. So, yeah. Georgia's juvenile death penalty was also invalidated following the court's decision in Roper v. Simmons, which forbade the death penalty for defendants who were under the age of 18 during the commission of their crime. The Georgia statute had permitted the death penalty for defendants who were 17 at the time of their crime. That's a good point. You were around in 2013, and we're glad for that, Flash. Okay, now we have LWOP, so life without the possibility of parole. Georgia's life sentence without the possibility of parole statute was enacted in May 1993 and allowed juries to deny parole to defendants convicted of certain high felonies, including murder. Presently, all 34 states that authorize the death penalty have enacted similar legislation. Georgia's LWOP legislation may have significantly altered the administration of capital punishment in Georgia by restricting LWOP to murder cases in which the prosecution has filed notices of intent to seek the death penalty. As a result, prosecutors may seek the death sentence in cases they do not believe are deserving of the death penalty, but they do believe warrant LWOP. For example, in 2001, Devonia Inman was convicted in Adel, Georgia, of the murder of Donna Brown and sentenced to LWOP. In commenting on his verdict and sentence, the Judicial Circuit Court District Attorney Bob Ellis remarked, quote, "Had we not sought the death penalty, we could not have gotten life without parole." This right here is the crux of the matter, guys, right? In terms of leveraging the death penalty in order to solidify LWOP as a sentence. Let me read that again. Had we not sought the death penalty, we could not have gotten life without parole. That's disturbing, right? Ellis further explained that by seeking the death penalty, he gave the jury the opportunity to deny parole to Inman. Even in jurisdictions that do not restrict the LWOP sentencing option to death cases, it is unlikely that a defendant charged with a death-eligible homicide offense would agree to a plea to an LWOP sentence without the threat of a death sentence at trial. So what this means is, like, for example, like I was saying before, right, you can only be eligible for the death penalty if you committed a homicide, right? But in many states, including North Carolina, you can be eligible for LWOP for things that don't include homicide, right? Great example if, sex crimes and things of that nature, right? You're very much facing LWOP. Okay. But what it's saying is it is unlikely that a defendant charged with a death eligible homicide, right? So, if So things that do involve a homicide, right, would agree to a plea without an LWOP sentence, without the threat of a death sentence at trial. So what they're saying is it's still different, because if only cases that involve homicide are eligible for the death penalty, which is the case, that still changes the nature of the plea when you're looking at LWOP, because, again, the threat of death is only going to be there when you're dealing with homicide offenses. Absent the risk of a death sentence at trial, the defendant could do no worse at trial, there it is, than the LWOP plea offered by the prosecutor. Let me read that part again. Absent the risk of a death sentence at trial, the defendant could do no worse at trial than the LWOP plea offered by the prosecutor. There's your cost risk analysis right there, guys. Yeah, and I mean, that must have been a long time ago, because that did used to happen. I mean, that's what we were reading. That did used to happen, but not anymore. Getting a death sentence for something like SA. The defendant would be better off taking her chances, or his chances, however slim, at trial for the possibility of receiving a lesser sentence. This is particularly true in jurisdictions such as Georgia that permit judges and juries to impose a life sentence with the possibility of parole sentence for anyone convicted of murder or felony murder. In Georgia, the defendant and the prosecutor may enter into a plea agreement at any time up until the jury renders its sentence in the penalty phase. We read that earlier, that up until the penalty phase, they can still strike up a plea deal. The following section briefly outlines the major stages of a case from indictment through the penalty phase that differentiate capital from non-capital cases. Okay, cool. So capital case progression, indictment through arraignment. Georgia is an indictment jurisdiction, so grand jury is required to decide formally whether there is probable cause to believe that the accused has committed the specified crime. So let's just talk about this real quick. So indictment, right? As we know, in most states, there's two different ways for charges to be brought against a defendant. One is by an indictment, and the other is by what they call an information. And an indictment differs from an information because an indictment can only be sought through a grand jury, which is what it just says here, right? You have to, that comes from a grand jury. And so what's interesting, though, is that Georgia is an indictment only jurisdiction. So there you go. Flash is saying, you mean someone could take a plea during, I don't know, closing arguments? Yup. 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 Again, with death penalty trials being bifurcated, they could even take before the penalty phase, technically that would even mean after they're found guilty, but before the penalty phase begins. So that, I mean, that's what this is saying, right? As long as it's still the sentencing phase, or sorry. As long as it's still the guilt phase and hasn't moved on to the penalty or sentencing phase, they're synonymous, they can still strike up a plea deal before a sentence is reached. It's kind of similar to what we see with Bryan Kohberger, or, you know, that we've been discussing, which is like up until sentencing, it's not, you know, what do they say? It's not over yet. Like, in other words, there can still be things to happen. Now, you know, again, like if you take a plea deal, then there's a difference in terms of pre-sentencing versus post-sentencing in terms of withdrawing. We've talked a lot about that. But if you're in trial, this is what they're saying here is, like, at least in Georgia, if you haven't moved on to the sentencing phase or the penalty phase, they can still reach a plea. Now, the reason that might happen, for anyone who's curious, is because, again, you know, if the state isn't sure that they could get a death verdict from a jury, right, and that they would be risking it, that could be one reason. Potentially, if it's what the victims' families want or what have you. I don't know. I can't think of as many reasons for the prosecution to be motivated to make that deal, but they might talk more about it here. But definitely you can see reasons why that would be there would be motivation for the defendant, right, to make that deal. So, okay, so following the indictment, the accused may be eligible for the appointment of counsel. If deemed eligible for appointed counsel on the charge as a capital felony, 2 attorneys must be appointed before the accused is called upon to plead to the charges. So that would be the arraignment, which generally occurs at the arraignment. Yeah, keep reading. Prior to arraignment, a pretrial conference is held, and the prosecuting attorney must announce whether she intends to seek the death penalty and then file a notice of intent with the clerk of Superior Court. The Superior Court must then transmit the notice to the clerk of Supreme Court of Georgia. During the arraignment, the court must read the indictment and ask the defendant to plead to the capital felony and any lesser included offenses charged. The defendant is allowed to plead guilty, not guilty, or mentally incompetent to stand trial. capital trial. The court must impanel 42 prospective jurors, from whom the state and defense must select a total of 12 jurors and one or more alternative jurors if deemed necessary by the judge. All capital cases are heard before the Georgia Superior Court and conducted in 2 phases. 1, the conviction phase, also commonly referred to as the guilt or innocent phase, and if the defendant is found guilty of a capital felony, the penalty phase. Immediately prior to the conviction phase, the court must conduct a conference with the state, defense counsel, and the defendant to resolve several matters, including inter alia, any last-minute motions, stipulations, and objections to defense counsel. In situations where the defendant is found guilty of capital murder at the conclusion of the conviction phase, so this is literally what I was just saying, right? Okay, so they've been found guilty, right, at the end of the guilt phase. The case proceeds to the penalty phase, where both the prosecutor and defense counsel may present witnesses and evidence regarding the statutory aggravating circumstances, as well as non-statutory aggravating and mitigating circumstances. The jury may sentence the defendant to death only if they find one or more statutory aggravating circumstances beyond a reasonable doubt, but a death sentence is never required. Following a conviction, here it is, following a conviction, so after being found guilty, right, for capital felony and a sentence of death, the defendant may challenge her conviction or death sentence. Okay, so this is with after they've been sentenced. Found guilty and sentenced. 1, filing a motion for new trial with the Superior Court, or 2, filing a direct appeal with the Georgia Supreme Court. If the defendant does not initiate any sort of review, the case will automatically be appealed to the Georgia Supreme Court within 10 days of the filing of the trial transcript by the court reporter of the Georgia Superior Court. This automatic review will occur even if the defendant does not wish to appeal her conviction or sentence. It is worth emphasizing that it is very common for multiple years to elapse between the initial arrest and the trial in death penalty cases, so both parties have ample time to negotiate a plea agreement. The data analyzed for this study reveal that the average time between arrest and sentencing for defendants noticed for the death penalty and opting for trial was 31.9 months. The average time for defendants noticed for the death penalty but ultimately pleading at some point before the penalty phase was approximately 24.6 months. That's interesting. Let me read that part again. The average time, right, for defendants noticed for the death penalty but pleading was 24 points, so about 2 years. And from what I recall, where we were at in this particular case, Bryan Kohberger, was about 2.5 years. Or I think what Ann Taylor said was actually by the time they would have gone to trial, it would have been 2.5 years, actually. So maybe 2 years and 3 months-ish. For defendants noticed for the death penalty, irrespective of whether they pleaded or took their cases to trial, the average amount of time between arrest and sentencing was 27.9 months. By comparison, the average time between arrest and sentencing for death-eligible defendants not facing the death penalty, but ultimately convicted of murder, was 17.4 months. And those opting for trial, and 13.5 months for those who pleaded. So what it's showing you is the difference in time, right? And the difference in the length of time for each stage with death penalty, where they're seeking the death penalty, right? Versus cases that were death penalty eligible, but the death penalty not being sought. The specific data collected in Georgia and analyzed in this article are discussed in the next section. The current study analyzes 8 years of death penalty charging and sentencing data from Georgia between 1993 and 2000 and addresses each of the aforementioned modifications in an effort to assess more accurately the impact of the death penalty on the plea bargaining process. The data used for these analyses were collected from the Georgia Bureau of Investigation, GBI, the Georgia Department of Corrections, the Office of the Georgia Capitol Defender, the Clerk's Office of the, Supreme Court. Yep, Georgia Supreme Court, the Atlanta Journal-Constitution, and the U.S. Census Bureau. These data contain detailed information on each homicide case in Georgia with respect to the defendant, co-defendants, victims, judge, prosecutor, defense counsel, and the crime. As mentioned previously, the Georgia death penalty statute lists 11 elements making a crime eligible for the death penalty. These data allow for the determination, this is the narrowing of the pool as we always talk about, right? To determine of which defendants are actually eligible for the death penalty in Georgia. Information obtained concerning prosecutors' actual decisions to seek the death penalty in each case permit the examination of a genuine treatment effect. The more nuanced data also permit the inclusion of a much richer set of statistical controls than were considered in prior research. Again, prior research is the one study previous to this one. Yeah, I would agree. Georgia is scary. Yes. During the period under investigation, prosecutors filed a notice of intent to seek the death penalty in 400 cases, and 54 defendants ultimately received the death penalty. Yikes. Of the 395 capitally charged cases in which the method of disposition is known, 59%, which means 234, were resolved by plea, and 41%, so 161, were resolved by trial. So over half pled. With respect to cases that were technically death eligible under the Georgia statute, but in which the prosecutor declined to seek the death penalty. So again, eligible for death penalty, but the prosecutors did not seek the death penalty. 350 were disposed by plea and 551 disposed by trial. So what you're seeing is this huge disparity, right, of the cases that plea versus the cases that go to trial. So let's look at the percentages again. When they seek in Georgia, right, from what they studied here, in cases where the prosecutor did seek the death penalty, 59% pled and 41% went to trial. And then in cases that were death penalty eligible, but the prosecutor did not seek the death penalty, 39% pled and 61% went to trial. So a complete flip-flop versus less than half or more than half, depending on which one. In other words, you can see there's a direct effect, right, on whether or not the death penalty was sought in terms of the likelihood of pleading. And again, the important point being that in this second set of cases mentioned here, these were death penalty eligible, but they just chose not to seek it. Of the 724 cases resulting in a murder conviction that were ineligible for the death penalty, okay, so now these are cases that were ineligible. 30% were disposed by plea and 70% went to trial. So then this is taking it even a step further, comparing this to the cases where they were not eligible in the first place. 70% went to trial. The plea rate for cases noticed for the death penalty ranged from 38.7% in 1998 to 75% in 1999. The plea rate for death eligible cases that were disposed by plea in which the defendant did not face the death penalty ranged from 31% to 53%. Okay, empirical strategy, designation of treatment and control groups. The treatment group for the purposes of the study consists of defendants who were noticed for the death penalty. The control group was comprised of defendants eligible for the death penalty, but against whom the prosecutor chose not to seek the death penalty. So if you see treatment group, it means they sought the death penalty. If you see control group, it means they're eligible, but prosecutors did not seek the death penalty. The difficulty in defining the control group is specifying what qualifies as a death eligible case. Some analysts suggest that any homicide committed in Georgia could be death eligible, resulting from the state's felony murder statute and the B7 statutory aggravating circumstance. Recall that B7 reads, quote, the offense of murder, rape, armed robbery, or kidnapping was outrageously or wantonly vile, horrible, or inhuman in that it involved torture, depravity of mind, or an aggravated battery to the victim, end quote. Due to this ambiguity, two different approaches were adopted to identify death-eligible defendants, again, narrowing the pool. I know, right? Well, they still may offer a deal to Gardner and Fernandez. The first approach categorizes defendants as eligible for the death penalty based on the presence of at least one of the special aggravating circumstances listed in Georgia's capital statute. The presence of these specific factors in each case was assessed in two ways. First, data from a study conducted by the Atlanta Journal-Constitution on 2,328 murder convictions obtained between 1995 and 2004 were used to determine the number of aggravating circumstances present in the 967 murder convictions, which incident dates from 1995 through 2000 in that study. And then here's a chart. So we see it broken down by county. Okay. The second manner in which the presence of statutorily defined elements was determined was based on the presence of B1, B2, or B4 special circumstances from inmate records from the Georgia Department of Corrections and the Georgia Bureau of Investigation. Recall that under B1, a defendant is eligible for the death penalty when, quote, the offense of murder, rape, armed robbery, or kidnapping was committed by a person with a prior record of conviction for a capital felony. Okay, so they have to have a prior record. Okay. Under Georgia statute, capital felonies are defined as murder, rape, armed robbery, or kidnapping. A capital offense refers to statutorily defined capital offenses, not necessarily death-eligible offenses. The predicate offenses for which the death penalty can be imposed are murder, malice, or felony, aircraft hijacking, and treason. According to the B2 statutory aggravating circumstance, a defendant is eligible for the death penalty when, quote, the offense of murder, rape, armed robbery, or kidnapping was committed while the offender was engaged in the commission of another capital felony or aggravated battery, or the offense of murder was committed while the offender was engaged in the commission of the burglary or arson in the first degree. So this is actually kind of similar to what we saw with Bryan Kohberger with the felony. What was it? I think it was the one that ended up being dropped because it was redundant, but it was like, there was like some circular thinking there with like they wanted to charge felony murder that he was like in the commission of a burglary, but then the burglary statute read like being in the commission of a felony. So anyways, that's all water under the bridge, but it was very similar to this in terms of being engaged in the commission of another capital felony. So we have kind of a distinction here between having previous felony records, right? Previous offender versus being in the commission of an additional capital felony, okay? Defendants who are convicted of contemporaneously committing these crimes, so that would be like the situation, right, where it's like in the commission of another crime, or had one of these crimes initially listed. Okay, never mind. So both categories, whether it was previous to the charges at hand, right, or whether it was in simultaneously, they were categorized as death eligible. Defendants convicted of murdering multiple victims were also categorized as death eligible because multiple victim homicides satisfy the requirements of the B2 statutory aggravating circumstance. Again, B2 being committing another felony while committing another felony, right? Capital felony. So, and this is again, there's an overlap there with Idaho because multiple victims was one of the aggravators for Bryan Kohberger that they would have gone forward with. Death eligibility based on the presence of the B4 circumstance. Quote, offender committed the offense of murder for himself or another for the purpose of receiving money or another thing of monetary value. Oh, so like a hitman, was determined by a contemporaneous conviction for an economically motivated crime, i.e. robbery and theft. Admittedly, the three factors employed to determine death eligible defendants are narrow and ignore a host of other factors listed in the statute. But it is worth noting that prior research strongly suggests that the presence of multiple victims and a contemporaneous felony are the most commonly used factors in death sentence cases and thus account for a high proportion of death eligible cases. And again, overlap here with Bryan Kohberger because multiple victims, right, was one of the aggravators. And then again, while it ended up the state dropped it, but there was another one where it was like, again, the felony, whatever it was, the one where it was like contemporaneous, right? But it would have been the same thing here where it's like a contemporaneous felony. And of course, one of the reasons why it was redundant was because the multiple victims in and of itself is a contemporaneous felony. So consequently, these two types of aggravating circumstances are also the most common factors used by judges and jurors to justify death sentences, as well as the strongest predicators of a death sentence, even after holding other legally relevant factors constant. Perhaps more importantly, data on the death eligibility from the more detailed study conducted by the Atlanta Journal-Constitution overlap with nearly 80% of the cases in the current sample. So a more fine-grained assessment of statutorily defined elements is available for the vast majority of cases. Glad you're enjoying it, Flash. Hopefully some of our other school friends will be joining us. I don't know where they are, but hopefully they'll be here at some point. But even if it's just whoever's here, thank you for being here. And right now that includes you, Flash. So thanks for watching and for being here. Death eligibility was also limited to situations in which the defendant was ultimately convicted of murder. Obviously, prosecutors seek the death penalty against defendants prior to obtaining a guilty plea or guilty verdict at trial, but limiting the pool of death eligible defendants to those who are actually convicted of murder serves as a proxy for strength of evidence. Other scholars have employed this limiting strategy when examining capital charging and sentencing processes. Perhaps of equal significance is the fact that Georgia's murder statute does not include degrees of murder like many other states. That's interesting. Let me read that again. Georgia's murder statute does not include degrees of murder like many other states. Instead, the statute specifies that individuals may be charged with malice murder, which is intentional, or felony murder, which is unintentional, but during the commission of any other felony. Interesting. And only these two types of murder may be death eligible, depending on the presence of at least one statutory aggravating circumstance. Shout out to Cat Randall. Glad you're here. That's okay that you're lurking. We love you. We're happy you're here. Lesser degrees, in lessers in quotes here, of homicide are categorized as voluntary and involuntary manslaughter. It is very unlikely that prosecutors will offer a charge bargain from murder to manslaughter when the available evidence permits a conviction for murder, which requires a mandatory minimum life sentence. Similarly, prosecutors are not likely to seek the death penalty in cases in which they believe a conviction for manslaughter is warranted, even in the presence of aggravating circumstances that would make the case eligible for the death penalty if a murder conviction were obtained. Focusing exclusively on defendants subsequently convicted of murder, suffers from the drawback of excluding death notice defendants who are not ultimately convicted of murder. In these data, 28 individuals, so 7% of death notified defendants, were initially noticed for the death penalty but were later acquitted, had their charges dismissed, or were convicted of an offense other than murder. Nevertheless, a closer inspection of the data supports the previously stated intuition that prosecutors do not typically offer charge bargains in exchange for guilty pleas. Of the 12 cases noticed for the death penalty that resulted in a plea bargain for a charge other than murder, only 2 were for manslaughter. So when it says charge bargains, guys, what that talks about, remember previously we've talked about the different ways that they can strike a plea deal. One is dealing with the charges, right? So like instead of murder, we're going to give you manslaughter, whatever, right? Another is with the sentence. So when you see charge bargains, that means that they're like dropping certain charges and going with a lesser charge versus a sentence bargain, which we haven't talked, or that has not come up yet on this particular installment of part 4. But the sentence bargain would be the charge is the same, but the sentence is different, right? So of the 12 cases noticed for the death penalty that resulted in a plea bargain for a charge other than murder, only 2 were for manslaughter. Thus, the more cautious approach adopted in these analyses, i.e. under inclusion, in an attempt to most accurately compare apples to apples, would appear to outweigh its disadvantages. The second approach utilized to identify death-eligible defendants was to define all cases that ultimately resulted in a murder conviction as death-eligible. Because some scholars claim that capital statutes like Georgia's permit any homicide to be deemed death-eligible, this very broad definition of death eligibility was employed in order to determine whether the results are robust to the specific criteria used to identify the control group. And now we move on to Part B, the statistical model. There are essentially 2 reasons why death noticing and plea bargaining decisions might be related. First, the decisions may be causally related. Second, death noticing and plea bargaining may be related because they are caused by other shared factors, i.e. third variables, that may or may not be observed. And if these factors are taken into account, the relationship between death noticing and plea bargaining disappears. That is, the relationship between death noticing and plea bargaining is not independent of those other factors. In an effort to determine the impact of the death penalty on the decision to go to trial, a conditional fixed effects logic model is estimated according to the following equation. Oh boy. That's fancy math right there. Can anyone understand that? Oh my God. Wow. It looks like crazy Greek letters and stuff. Don't they have to have mitigating? They have to have aggravating factors. For the death penalty, in every state that I have ever heard of that still uses the death penalty, the standard is the state has to prove at least one aggravating factor beyond a reasonable doubt. They have to prove at least one aggravating factor beyond a reasonable doubt. The mitigating factors are what the defense can present if they so choose to mitigate the aggravating factors. So that could be things like, I don't know, they were abused as a child, or they have some sort of condition, or whatever the case may be. There's tons of different, the sky's the limit really, potentially with mitigating factors. Again, for anyone who hasn't heard me say this before, the rules of evidence do not apply in the penalty phase. And that is where you have your aggravating and mitigating evidence presented to the jury. So while the state needs to have, in order for the state to seek the death penalty, they need to have aggravating factors, right? But then once, if a jury finds a defendant guilty, then they move on to the penalty phase. What the charge upon the jury is that the jury has to find at least one aggravating factor beyond a reasonable doubt. And that's the case that the state will present. Usually there's many options, right, for the aggravating factors. And if you're the state, the more you have, the better, because then your odds increase that the jury will find at least one beyond a reasonable doubt. And the other thing is that they don't, they have to, oh, fuck, now I can't remember. I believe they have to be unanimous on the one aggravating factor. But now I'm second guessing myself because it's been a while since I've looked that particular thing up. Hold on, give me 1 second here. Okay, give me a second. It's loading. It's loading. Don't apologize. It's all right. It's all good, Flash. I appreciate your questions. So while it's loading, I'm going to keep reading, and then I'll come back to this since it's loading here. So we have this crazy looking equation. So it says where I indexes the defendant. See, dude, I'm not even going to read this because I don't know that any of us can fucking understand what this is. So we're going to skip past that. They're going to do the math for us, guys. So don't worry. Okay. Okay, let me just see if this is loaded. Okay, it has loaded. So let's just see here. Right, they can't consider the penalty during the guilt phase of the case. Okay, fine. I'm just looking for the part. Okay, there it is. If you unanimously decide that the state has so proven, there we go. So I was second guessing myself, but I was correct. They have to be unanimous on the one aggravating factor. So in other words, let's say they present 6 aggravating factors, right? The jury has to be unanimous on which one of the 6 the state has proven beyond a reasonable doubt. So it can't be that if 6 jurors believe that factor number 1 was proven beyond a reasonable doubt, and then 6 jurors believe factor number 2, right? They have to be unanimous on the one factor. There you go. Okay. Always good to double check. So back to this. Okay. So although the model controls for average differences across jurisdictions and average differences across years, it does not take into account omitted covariates that are case specific. Prosecutors do not randomly select cases for the death penalty, so the estimation of the true impact of capital punishment on trials may be biased and inconsistent if the death noticing decision is correlated with some other unobserved variable or variables that also has a causal impact on the decision to go to trial. For example, endogeneity bias. I don't know what that is, so let me look it up. I have no idea, guys, what that means. Let's take a look. Wow, it doesn't have a simple definition. Endogeneity occurs when an independent variable in a statistical model is correlated with the error term, meaning it's influenced by factors not explicitly included in the model. I don't understand what that means. Well, oh, that's so funny. People also, what is endogeneity, or I don't even know how to pronounce it, but what is it in simple terms, someone asks? It refers to where the effect of an independent variable on a dependent variable, this is the same thing. Oh my God. Let me just read it anyway. Where the effect of an independent variable on a dependent variable cannot be causally interpreted because it includes omitted causes leading to biased estimates. Okay, that was not helpful. Anyone who knows what this is in the chat, then you are my hero, because if you can explain it in simple terms, because apparently no one else can on the internet. Welcome, Heather. Happy to see you as well. Woo, Heather's here. Okay. So relatedly, if a death noticing decision is also influenced by a prior failed plea negotiation, i.e. simultaneous causality, death noticing is also endogenous because it will be correlated with an unobserved variable influencing both decisions. Preliminary plea negotiation. The fixed effects logic model discussed earlier implicitly assumes that all factors simultaneously influencing the death noticing and trial decisions are included in the model via covariates and circuit and year fixed effects. This may be a questionable assumption, so several alternative models that explicitly account for co-founding omitted variables at the case level are examined in Part 6b. This is way over my head. This sounds like a mathematician type of deal here, guys. Let me know if y'all understand this. I'm sure it will be broken down after, but you have to show your work, right? This author is showing his work. That's what he's doing. I mean, here we go, like all this. So enjoy looking at this chart. If you can understand it, good for you. Many happy returns to you, or what have you. Yeah. So there you go. And we have another table. Excellent. Good looking table. What do you guys think? Very mathy, very numbersy. Looks legit. And another one. Wonderful. Okay, missing data. An additional complication with analyzing official homicide records is incomplete information, i.e. missing data. The vast majority of statistical analyses must be performed on a full data matrix. Therefore, the common practice among social scientists is to perform case-wise deletion by eliminating observations that have missing data on one or more variables. Case-wise deletion is problematic because it, one, potentially forces researchers to discard much useful information about the relationships between variables, and two, results in inefficient parameter estimates due to a reduction of sample size, and three, may bias parameter estimates if the data are not missing completely at random, i.e., if the missing data are not a random subset of the overall population. There is missing data on at least one variable in approximately 1/3 of the observations in the Georgia data. However, when it is possible to predict the probability that a variable is missing information for an observation, using information from other covariates in the data, the most appropriate strategy is to attempt to predict those missing values. Okay, so he's explaining things that he's predicting for, basically. This is particularly true when examining the capital punishment process because death penalty cases in Georgia and elsewhere are very rare occurrences. So it is crucial to retain as much information as possible. So basically what he's saying is, like, where there's missing data, you could just delete certain things, right, of the data set, right? But then you lose all that data entirely. Or what you can do is use other data to basically predict the probability. And I'm paraphrasing. This is what I'm gleaning from, right? And that when you have a very small data set, for example, death penalty cases in Georgia, right, that there's not that many to begin with, the second option is the better option. That's what I'm gleaning from this. Over the past 2 decades, quantitative methodologists have developed several approaches to, quote, guess, end quote, the values of missing data by using other information about the association of the variable of interest with other variables in the data. So that's basically what I was just saying. A regression-based multiple imputation approach is employed in these analyses, which provides a significant improvement over simple imputation methods and traditional simple imputation strategies. So I'm going to skip ahead a little bit because this is just a little bit cerebral, and I don't know that this is as helpful for us, but people who are like statisticians in this area definitely will be loving this part. But let me see if I can skip ahead to where it's a little bit more digestible for myself and you guys. Yeah. Results. Excellent. Fixed effects logic specifications. As table 6 displays results from 4 different specifications. Across all 4 models, defendants noticed for the death penalty were significantly less likely to opt for a trial, i.e., significantly more likely to accept a plea. Models 1 and 3 analyze the impact of the death penalty on the probability of going to trial for defendants classified as death eligible according to the first criteria discussed. Eligibility based on the presence of statutorily defined elements hereinafter DE. Models 2 and 4 analyze the impact of the death penalty on defendants classified as death eligible, DE, based on the second criteria, murder conviction, hereinafter MC for murder conviction. All specifications include judicial circuit and year fixed effects, as well as the controls for the number of co-defendants, defendants' race and ethnicity, gender and age, defendants' employment status at the time of arrest, defendants' marital status, number of statutory aggravating factors, contemporaneous felony conviction, prior felony conviction, whether the defendant graduated from high school, number of children. Okay, oh my God, there's so many things. I'm not going to read all of those. Oh my God. Okay, let me go ahead a little bit here. Okay, now here's a zoom out so we can see this table. All right, here we go. So this is what we want to see, right? So method of disposition. So here we go. So in a death penalty case, right, the probability of a plea, you got 0.6, and then trial is 0.4, and then in non-death, they're exactly the opposite, guys. Look at that. They're exactly the opposite of each other. There you go. Okay, there's some more tables, some more math. Another table. I don't know where my reading partner is, but there's Kane. Hi, Kane. He hit his head on the car door on the way to go get. Oh no! Are you okay? And did you get your ice cream? Please let us know because we are invested. We want you to get your ice cream. Although Twiz would have some words to say about your brand of choice there with Bluebell, as I'm sure you are well aware. Kane, Also, shout out to the rat daddy. How are the rats? I really hope that they get little galoshes and slickers for all the stormy weather that you're having, which we are also having. Kane, if you feel like coming on and reading since Twiz isn't here, let me know. Okay, some more math. Excellent. More math. Okay, I think I'm actually going to move on to what we might come back to this, but here's what I really want to get to, guys. This is perhaps the most exciting part of all this in our installment, which is this one here. And this is recent. I'm so excited to go through this, guys. Are you guys ready? All right, this is awesome. Attorney perspectives on guilt, innocence, and legal advice in the current plea system. Abstract. You guys ready? In the American criminal justice system, the vast majority of criminal convictions occur as the result of guilty pleas, often made as a result of plea bargains rather than jury trials. The incentives offered in exchange for guilty pleas mean that both innocent and guilty defendants plead guilty. We investigate the role of attorneys in this context through interviews with criminal defense attorneys. This is really the culmination of everything we've been going through with this entire series. Y'all are going to love this. We examine defense attorney perspectives on the extent to which innocent defendants are and should be pleading guilty in the current legal framework and their views of their own role in this complex system. So let me just say something real quick, and then I'm going to read this again. Remember, we've talked about this before. There are times where the plea deal really does favor the defendant. Katie McBanois, that was a no-brainer. There's other examples. I gave you guys a great example the other night of a North Carolina case. Now, so the point being that even if you actually are innocent, right, that they could still have enough evidence. Let me just read this again so you guys see what I'm saying. We examine defense attorney perspectives on the extent to which innocent defendants are and should be pleading guilty in the current legal framework and their views of their own role in this complex system. So this is getting to the heart of the question that I had initially, which started this entire thing, which is like, if they believe their defendant is factually innocent, if you're the attorney, right, is your role as the attorney, like, I already kind of knew the answer, but I wanted just to see more about what other people thought, right? Like, how do you, I'm not instruct, but how do you discuss this with your client, right? Like, is it more important if you believe they're factually innocent that they maintain their innocence, right? This is the whole question. If they're factually innocent and you as their attorney believe they're factually innocent, how would that affect, or should that affect, and does that affect the role that the defense attorneys play in whether or not to accept a plea deal where in fact the defendant pleads guilty? Okay. I'm going to read this one more time because I think this is really important. This is the whole crux. We examine defense attorney perspectives on the extent to which innocent defendants, so in other words, how often, right? Innocent defendants are and should be pleading guilty in the current legal framework and their views of their own role in this complex system. We also use a hypothetical case to probe the ways in which defense attorneys consider guilt or innocence when providing advice on pleas. Results indicate that attorney advice is influenced by guilt or innocence, but also that attorneys are limited in the extent to which they can negotiate justice for their clients in a system in which uncertainty and large discrepancies between outcomes of guilty pleas and conviction at trial can make it a sensible option to plead guilty even when innocent. And there's that leverage. There's that leverage. Results also suggest conflicting opinions over the role of the attorney in the plea bargaining process. Oh my God, I can't wait to read this. The attorneys have differing opinions. They have conflicting opinions. The different attorneys do over the role of the attorney. This is all about defense attorneys. They surveyed defense attorneys and talked with defense attorneys. Okay. All right. In the current American criminal justice system, the majority of convictions occur as a result of guilty pleas rather than trial. In 2015, 97.1% of federal cases that were resolved via a guilty plea by the defendant. 97.1%. The high rate of pleas has occurred largely as a result of the practice of plea bargaining, where a defendant can agree to plead guilty in exchange for a reduced sentence rather than exercise their right to a jury trial. This practice is well known and often accepted as an efficient way to dispose of cases. We don't need an example here. We know what it means. Well, so, I will say this part is interesting here, right? So a plea agreement can benefit both parties, right? That's one thing. This rationale has been used to justify plea bargaining through the idea that a defendant can get a reduced sentence by confessing to something that they have done. However, academics and legal commentators have noted that characteristics of current plea bargaining practice mean that it's not just operating in a way that allows defendants to get a reduced sentence by confessing to something that they have done, but also to encourage or even coerce innocent defendants into pleading guilty. And there's Flash saying, I mean, look at the BK. He'd been saying he was innocent for years and then says guilty. It makes sense. Yep. But also to encourage or even coerce. And there's that coerced plea where we started with the beginning of this whole series. We started with the first one we read was that article called The Coerced Plea, the Scourge of the American, or the Scourge of the Criminal Justice System, the coerced plea. So we started with the coerced plea. Then we moved on to leveraging death. So that's plea deals in death penalty cases. And now we're on to what do the defense attorneys have to say? Commentators disagree on the way that the current system functions. Some have argued that it is not a problem that innocent defendants plead guilty because innocent defendants should be able to enjoy the benefits of pleading guilty, including reducing or altogether avoiding custody. Others suggest that prosecutors are encouraging those who are unlikely to be convicted at trial to plead guilty by offering highly coercive plea deals. I think both of these are true, and this is why it's tough, right? This is why it's tough, and that's literally what got me thinking about all this. I mean, I've been thinking about it, but even more so recently, because if you were to say, that's the thing, people who are innocent of a crime, it's not fair to them that they shouldn't be able to enjoy the benefits offered by a plea deal if that's what's best for the client, right? Just because, you know what I mean? In other words, if you've got a really good plea deal, because there's bad ones and good ones, right? If you've got a really good plea deal, that would be unjust, right? To say that only people who actually are guilty can take advantage of that, right? Innocent people should have that benefit as well. However, it's skewed to begin with, right? Because you've got these coercive plea deals. In either case, the decision to plead guilty appears to have become a tactical decision rather than a moral decision to admit guilt. Let me read this again. In either case, the decision to plead guilty appears to have become a tactical decision rather than a moral decision to admit guilt. You guys, everyone who is following this case and any case, this is the key takeaway, because so many people don't understand this. And everybody was up in a ruckus after Bryan Kohberger pled guilty. And it's like, because here's why. Everybody's all focused on the moral element of it or the emotional element of it. And that is not the factor in a death penalty case, people. For fuck's sake. In this context, the role of the defense attorney is complicated. It will often involve trying to help a client navigate many competing considerations, assessments of risk, and assessments of factual guilt or innocence. It is not clear whether attorneys should be and are advising clients on the decision that they should make based on an assessment of their best interests, or whether the proper role of the attorney is just to provide the relevant information to a client and then leave them to make the best decision for themselves. You guys, isn't this interesting? This is just the abstract. This already is so interesting because you can see that for the attorneys, they're not all in agreement. And it sounds like they're dealing with their own, considerations here on how to go about it. And this is really interesting to me. I'm going to read this part again. It is not clear whether attorneys should be and are advising clients on the decision that they should make based on an assessment of their best interests, or whether the proper role of the attorney is just to provide the relevant information to a client and leave them to make the best decision for themselves. Wow. The added consideration of factual guilt or innocence makes this process even more complex. In this paper, we interview criminal defense attorneys about their perspectives on and experiences with the police system. We examine responses to probe the extent to which innocent defendants are and should be pleading guilty in the current legal framework, the way that attorneys view their role in this complex system, and the ways in which defense attorneys consider guilt or innocence when providing advice on pleas. And that right there is maybe perhaps the most interesting part of all of it, right? Because this is what I've been thinking about, right? If you're a defense attorney and you believe that your client is factually innocent, and you're being faced with a plea deal, how do they weigh this out in terms of encouraging them to plead guilty? So let me read this again. We examine responses to probe the extent to which innocent defendants are and should be pleading guilty in the current legal framework, the way that attorneys view their role in this complex system, and the ways in which defense attorneys consider guilt or innocence when providing advice on pleas. Isn't this amazing? When did ruckus get back into the lexicon? Did I say ruckus? If I said ruckus, I have no idea. I don't know what other people say, but if I said it, it wouldn't surprise me. I'll just say things, I don't care what other, I don't know that anyone else uses it. If someone else uses it, that would be kind of funny if I said it and someone else is saying it randomly. Okay, the plea decision. Defendants offered a plea deal must make a decision as to whether they want to exercise their right to trial or whether they want to plead guilty and receive a certain sentence and charge that is less severe than they would receive if convicted at trial. The terms offered as part of a plea deal can create extreme pressure to plead guilty. In the most extreme case, a guilty plea can be the only way to protect against a risk of death through the imposition of the death penalty as the result of trial. Yep. This means that plea decisions are not as simple as guilty defendants deciding whether or not to admit guilt. You guys, let me read that part again. This means that plea decisions are not as simple as guilty defendants deciding whether or not to admit guilt, but are a tactical decision based on risks and potential consequences. Y'all have been hearing me say this all along, as according to Bryan Kohberger, but just in case anyone's like, who's this squirrel and what does she know? Like, just don't even take it from me. Take it from this. Cost risk analysis. Just like I've been saying all along. The primary theory examining plea bargaining as a tactical decision is known as bargaining in the shadow of trial. According to this theory, parties will forecast the expected sentence after trial, discount it by the probability of acquittal, and offer some proportional outcome in exchange for a guilty plea. Also, shout out to Too Fast. Welcome back, my friend. Don't get a ticket for no seatbelt in Moscow. Bill will bring technology. No kidding, right? Okay, so defendants can then consider the options, including potential outcomes at trial, and make a rational decision about which is preferable for them. Typically, a risk-neutral defendant is expected to plead guilty if an offered sentence is less than or equal to her expected value of going to trial. In terms of deciding which option, plea or trial, is preferable to a defendant, empirical research has confirmed that risk preferences, probabilities of conviction, and potential sentences influence defendant decisions. However, research also suggests that defendants are influenced by whether they are guilty or innocent. Pressure from the prosecutor, expediency, and acquiescence, including acquiescing with attorney advice. This makes the plea decision a complex one that is influenced by defendant psychology and attorney practice, as well as by the options involved. This also means that guilt or innocence can become a secondary concern in the decision-making process for both defendants and attorneys, and that innocent defendants plead guilty. Pleading guilty when innocent. All right, buckle up. There is now extensive evidence to suggest that innocent defendants, as well as guilty defendants, plead guilty. In a study of guilty pleas in youth and adults who pleaded guilty to felonies in New York, this study found that a sizable portion of both youths and adults who had pled guilty claimed to be completely innocent. 27% for the youths and 19% for the adults, respectively, or at least not guilty of the crime with which they were charged. And that would be 20% for the youths and 41% for the adults. In another study, Covey, and I feel like I recognize that study anyways, examined guilty plea rates among defendants in a case that produced a large number of exonerees. So people that were exonerated. He classified participants in this case as innocent, maybe innocent, or guilty, and found that 77% of those classified as innocent pled guilty, compared to 88% of those. So I'm going to back up, and then I'm going to read this again. What this study, or what this I guess it's a study, and this article is getting at, we always talk about guilty or not guilty, right? And innocence isn't usually really a factor. That doesn't really apply here, because what this is really getting at is how many times do innocent people plead guilty? Like innocent, not just, you know what I mean? And part of that has to do with this, right? Because not guilty is a determination by a jury. If they don't go to trial, there is no not guilty, right? That's a jury verdict. So in other words, what you're dealing with is, did they do it or did they not do it, which is what we usually don't ever really discuss from a legal perspective, right? We're looking at, did the state, did the prosecution, did the government prove it beyond a reasonable doubt? Guilty or not guilty, did they prove it, right? However, at this juncture, when we're examining the role of the plea deal and the question of, do people, which we know they do, right? But the factors by which and how often, how frequently do people who are factually innocent plead guilty to crimes they did not commit? You're not dealing with a question of not guilty or guilty because there was no trial. You're dealing with a question of innocent or guilty, essentially, right? Hopefully that makes sense. So, okay. So he classified participants in these cases as innocent, maybe innocent, or guilty, and found that 77% of those classified as innocent pled guilty, compared to 88% of those classified as guilty and 89% of those classified as maybe innocent. This phenomenon has also been confirmed through real wrongful convictions. In 2017, about 18% of exonerations listed in the National Registry of Exonerations were categorized as of involving a guilty plea. The true number of wrongful convictions from guilty pleas is likely even higher than this, since exoneration is particularly hard for defendants who have pled guilty. The irony, though, right? In other words, oh my God, wrongful convictions can often result from a guilty plea. However, it's tough to get exonerated after you plead guilty because you pled guilty. So catch-22, right? Fucking hell. Oh my God. Oh my God. Oh my God. Guys, help. All right. This particular study identified 3 specific situations in which innocent defendants appear to be pleading guilty. Low-level offenses where a guilty plea allows release from jail, cases where defendants have been wrongfully convicted, prevail on appeal, and are then offered a plea bargain that will assure their immediate or imminent release, and cases where defendants are threatened with harsh alternative penalties if they do not plead guilty. Oh my God. That, speaking of the coercive plea deal, right? Jesus. In some of these situations, the decision to plead guilty seems justifiable and arguably even the only sensible decision. In these situations, there is an added complication for attorneys who may believe that the best representation is provided by advising the client to plead guilty, despite being or claiming to be innocent. This is a complex balance, since it is not desirable for innocent defendants to plead guilty, but equally, it is not desirable for innocent defendants to risk severe punishments if convicted at trial. Let me read that part again. This is a complex balance, since it is not desirable for innocent defendants to plead guilty, but equally, it is not desirable for innocent defendants to risk severe punishments if convicted at trial. Like I was saying before, those who are factually innocent deserve to enjoy all the same rights as those who are guilty if there isn't a favorable plea that is offered to them. Although I hate that we have to be there in the first place, but there it is. This balance can be even more complicated, where even the sentence as a result of the plea has serious negative consequences for a defendant. For example, where it means they will have serious criminal conviction for the rest of their lives and remain unexonerated, or where even a misdemeanor conviction will have severe consequences such as loss of employment or deportation. Here, innocent defendants can end up suffering very serious adverse consequences to avoid the threat of even worse consequences at trial. And there's where the coerciveness comes in, especially since the advice of attorneys has been shown to be an important predictor of defendant plea decisions. It is important to understand how they typically advise in these cases and how defense attorney advice might be shaping plea practice. There's Super Planner Girl. We've been giving you a lot of love on the other live streams since your surgery. I don't know if you've heard it or not, but we love you. How are you doing? Let us know. Everyone send hugs and positive. Scroll by to Super Planner Girl. Because we love her. Okay, the role of attorneys in the plea system. As experts on the legal system tasked with advising clients, attorneys have an important role in the plea bargaining process. This is particularly true since, as noted above, the advice of attorneys has been to show an important predictor of defendant plea decisions. However, many questions about attorney advice in this area, particularly the way attorneys consider suspected guilt or innocence when giving advice, remain unanswered. Wait, so Kane, did you get it looks like you got your ice cream, but you're seeing double. Well, maybe ice your eye, maybe not with your ice cream, but with an ice pack. And Super Planner Girl says she's improving every day. Glad to hear it, Amanda. Okay. It is unclear whether attorneys should ever be advising an innocent defendant to plead guilty. Ethical rules typically call on attorneys to refuse to offer evidence that they know to be false. And that is exactly what got me questioning this in the first place, because I was like, what are the ethical considerations? Because if they know it's false, can they advise a defendant to do it, right? Normally, that would never fly. But in the role of the plea deal, it's where it's a gray area, right? Ethical rules typically call on attorneys to refuse to offer evidence that they know to be false and to take reasonable remedial measures where false testimony is offered. However, this is clearly not thought to apply in the case of innocent defendants pleading guilty. And if anything, it might be the one exception in terms of the ethical duties of an attorney. This is why this is so interesting to me. Especially in the context of Alford pleas, where defendants can plead guilty while explicitly claiming to be innocent. Considering the case of the West Memphis 3, where a plea bargain secured the release of the defendants after 18 years of imprisonment and ensured that none of the defendants would be executed. And this study concludes that almost any criminal defense lawyer, including the authors of this essay, would have advised them to take it and would have cajoled them to take it if they hesitated. This suggests that attorneys are limited in the extent to which they can really negotiate justice for their clients, and their role becomes protecting a client from the most severe potential consequences. Research suggests that some defense attorneys may be going too far in this regard, having a bias towards plea bargaining in legal cases, could happen, persuading clients to enter into plea agreements, and participating in a meet and plead system. Oh God, that makes me feel nauseous. In which, oh God, I can't read it. I have one hand over my eyes, guys. I have only, I'm peeking out from one eye. I'm scared like a little kid as I read this part. Participating in a meet and plead system in which defendants sometimes meet their attorney for the first time at a court hearing, during which a guilty plea is offered, accepted, and entered. Yep, that's why. I knew where that was going. That's why I couldn't look. I had to peek from behind my hand, like I'm scared of a ghost or something. Oh my God. 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 This is supported by interviews with defendants reporting infrequent contact with their attorneys prior to accepting plea deals and very short time periods in which to make their decisions. Let me read this part again. Guys, holy shit. Research suggests that some defense attorneys may be going too far in this regard, having a bias towards plea bargaining in legal cases, persuading their clients to enter into plea agreements, and participating in a meet and plead system in which defendants sometimes meet their attorney for the first time at a court hearing, during which a guilty plea is offered, accepted, and entered. This is supported by interviews with defendants reporting infrequent contact with attorneys prior to accepting plea deals and very short time periods in which to make their decisions. Kane, are you saying you're going to come read? Are you okay to? I forgot about that part. Can you see okay to read with your head injury? I have no idea where Twaddlestick is, but you know what? I actually remember to send him a special text before I went live. So if anything, normally I remember at the end or halfway in or sometimes towards the beginning, but it was the first thing I thought of, and there's no quiz. Do you want to come read, Kane? Let me know. Are you able to read? Attorney obligations in plea cases are being clarified through case law, specifically cases on ineffective assistance of counsel. Oh boy. In a recent case, the Supreme Court ruled in favor of an immigrant whose lawyer falsely told him that pleading guilty to a drug charge would not lead to his deportation, when in fact accepting the plea agreement would certainly lead to deportation. In that case, the defendant's lawyer urged him to plead guilty in exchange for a lighter sentence and falsely told him that he would not be subject to deportation after doing so. Wow. The defendant filed a motion to vacate his conviction after learning that he would be subject to deportation as a result of his plea, and this was approved by the Supreme Court. There are also examples of ineffective assistance of counsel in which an attorney advised a client to go to trial and not plead, such as the well-known cases of, you know what? Y'all, Katie McBanois needs to be on this list at some point. I know it's too soon for that, but literally, I've been saying this all along. Ineffective assistance of counsel on behalf of her attorney. What's her name? Tara something. Because literally, we all know Katie wanted to take that plea deal and her attorney told her no, don't do it. I heard somebody say it the other night too, and I forget who it was. I've been saying this, but I heard somebody else say it. I forget. It was some attorney on LawTube that it will go down in history of the biggest mistake of all time in terms of plea deals. And I couldn't agree more. Like Tara Kavash, I think. I'm trying to remember the attorney name. But anyways, ineffective assistance of counsel. Now, here's what's so interesting is that Katie McBanawa is still using that same attorney on her appeal. And guess what attorneys are not going to do when they're their own appellate attorneys? And this is why you never do this, because she's not going to say ineffective assistance of counsel on herself. Deep breaths. Literally, that was ineffective assistance of counsel. Disgusting. Yeah, Kane, don't sleep for a couple hours if you hit your head. Look, I've had a lot of concussions, so let me know if you need any concussion advice. If you're having trouble, like Kane, if you're having any trouble looking at light, if light is bothering you or sound is bothering you, or you feel like you want to go to sleep and it seems kind of unreasonable, or if you have any muscle weakness or like not coordination, like are your hands like not picking things up normally, these are all signs that you need to go and get like your head scanned. So Twiz, no one cares anymore. Your lame excuses. You know what I have to say about that, Twiz? You know what I have to say about that? Hang on.
Leave your stupid comments in your pocket.
That's what I have to say about your excuses, Twiz. Do you want to come on and read? Whoever's just getting here, y'all have missed some really, really, really interesting things. So make sure you go back on replay, crew. As always, it'll be timestamped. But we are here in the thrux of it, throws. I think I combined throws and crux and got thrux. Anyway, new word, new squirrel word, thrux. Okay. Right, ineffective assistance of counsel. There are also examples of ineffective assistance of counsel in cases in which an attorney advised the client to go to trial and not plead. Like with Katie McBanawa, such as the well-known cases of these ones. Someday you will see Katie McBanawa will be on this list. In Fry, it was found that defense counsel was ineffective because of failing to convey a plea offer to a defendant. In Loeffler, it was found that defense counsel was ineffective when incompetent advice caused the defendant to reject a guilty plea and proceed to trial. Literally what happened with Katie McBanawa. Justice Kennedy delivered the majority opinion, which held that that's the thing. Like literally, that's literally her exact issue, Katie McBanawa. But the problem again is that her same trial attorney is doing her appeal. I can't keep reading. Justice Kennedy delivered the majority opinion, which held that the proper test is whether, absent the ineffective assistance of counsel, a defendant would have accepted an offered plea that was less severe than his eventual sentence, and the trial court would have accepted the terms of the plea. These cases all provide clear examples of ineffective assistance of counsel. However, they also raise interesting questions about exactly what the responsibilities of attorneys are in the context of plea agreements. Is the only responsibility to convey a plea offer and to provide accurate information? Does the responsibility extend to providing sound advice based on the best interests of the client? And should clients' claims of guilt or innocence influence attorney advice? Let me read this again. These are the three main questions here, okay? Is the only responsibility of the attorney, right, to convey a plea offer and to provide accurate information? Does the responsibility extend to providing sound advice based on the best interests of a client? So to actually advise them. And should the client's claims of guilt or innocence influence attorney advice? Kane, I'm worried about your head and maybe you need to go to the ER. But if you want to come on and read, I don't know how to send you a link though, Kane. I don't know how to send you a link because I don't think you use Discord. And I don't have your phone number because I'd have to send you a link. Twiz, however, has co-host status, as everyone knows. Okay. A small number of studies have examined plea recommendations. One study using an experimental design showed that probability of conviction, potential sentences, and defendant preference all influenced attorney plea advice. Put it in the chat. Can I even do that? I don't even know if I can put links. I'll try it. Let me just see here. Okay, we're going to see. You know what? This will be good because then if Kane comes on, then we can assess the extent of his head injury. This will be 2 for 1. Kane reads in lieu of Twiz and also an amateur concussion assessment, if you will. There you go. Can you click on that, Kane? What does that mean, Heather? Waskobomskiskim? I'm trying to read. Wasusmomskim. I don't know what that says. We'll see if Kane pops on. He's got his ice cream, it seems like. He's hit his head. That's where we're at in the Kane scheme of things. Kane hit his head, Twiz. And I said you would have some thoughts on the ice cream. He was getting Bluebell ice cream, and I was like, Twiz would have thoughts. F-bug heed Quebec. Yeah, there you go. That's a good idea, Flash, to delete it after he comes into Trollston. And now I don't even know that he's going to have the wherewithal to click on it given the head injury. But we'll see. Okay, a small number of studies have examined attorney plea. Oh, and he's here. Hey.
Hello? Is this Purge?
Is this the Purge?
Are we purging?
What is that sound?
What sound? Oh, it's the fan on my AC. I don't even have the AC on. It's the fan on my AC. I'm hearing you twice. Hold on.
Can you reduce background noise, Kane? You know how to do that?
Yeah.
Go to settings and go to audio and click reduce.
Is that better?
That's much better. Yeah.
Are you happy now? I'm happy now. Chelsea.
That is so much. Y'all in the chat, let him know how much better that is. That's amazing. It does a great job.
Can I get a round of applause, please? Hold on.
Yeah.
Do I start reading now?
Okay. Yes. Here, you can start reading. I'm gonna highlight it as you. Can you read it? Here, hold on. Let me make it bigger. That's as big as I can make it.
I think if I hit my head too hard, I just need a chiropractor. That should be over.
Kane. Okay, let's see how you do reading. I'll be able to tell. I've had a lot of concussions. All right, I'll highlight.
A number studies examine plea recommendations. Study 1 using Spear. Oh, am I doing right? Showed that probability of conviction, potential sentences, and defendant preference all influence attorney plea. Kramer, Walbransky, Heelroom, 2007.
Okay, good job, Kane. You don't have to read the people. These are people from the study. You don't have to read their names, but thank you. I appreciate your enthusiasm.
Check.
Okay.
Another study has shown that attorneys can be influenced by the race of a client when given plea advice, feeling that they could obtain better plea deals with Caucasian client than with a minority client. Why'd you give me this one to read? Even though when controlling for perceptions of guilt. However, the relationship between guilt and innocence, attorney advice, and plea decisions has not previously been examined in the literature. In this paper, we utilize attorney interviews to probe the extent to which innocent defendants are pleading guilty in the current system. Oh. The way that attorneys view their role in this complex system and the ways in which defense attorneys consider guilt or innocent when providing on advice on pleas. Can I ask you a quick question, Chelsea?
Of course.
Do you think there would have been a different outcome had BK had a private lawyer?
To be honest, I don't. Well, it could have been a worse outcome, to be honest. I think Ann Taylor's phenomenal. A less skilled attorney may not have gotten to the point where the state would have even done a plea. Remember, the whole thing about a plea, right, is it has to benefit both sides. There had to be reasons for the state to offer this, right? And we've talked a lot about it. I mean, you have to have a defense team that's pointing out all the flaws, that's giving you the run for your money, that's holding your feet to the fire, that's making you work for it, making you, like, she got the state to be scared. Now, having said that, we know there's a lot of problems with their case, right? And it's like, well, it shouldn't take that much. But you know what? There's other defense attorneys that, like, I think that more work went into that than probably what we can even imagine to really hold their feet to the fire. So I think with a private attorney, it could have even gone worse.
Depending on how much work they put in.
Right. And depending on just, in other words, I don't think it could have gone any better. That's what I will say. Whether they were a private attorney or not, I don't think he could have had a more zealous defense. 100%. I believe that wholeheartedly. He could not have had a more zealous defense. That is my opinion of it. I appreciate the question. What do you think?
Thank you for the answer. That's a good answer. Thank you. Check. Participants.
Wait, hold on. Kane, what do you think, though?
I don't know. I'm mad at Twiz right now. I'm blaming him for everything.
Why are you mad at Twiz?
I thought we were all mad at Twiz right now.
Oh, right. Yeah, no, we are. We're mad at you, Twiz.
This would be a great time to give me his wrench. I'm just saying. That would really teach him.
Twiz is saying, did he turn the fan off or reduce background noise? I know, right? What a difference, right? He reduced background noise via.
Do I look prettier?
You look gorgeous.
Thank you. I just got my hair and my nails did.
Got my hair done and your nails did. Wait, hold on. The Misty Elliott, right? What is it? Hold on.
To the window.
Oh my God! Now we've got more people to. I forgot to delete.
BP.
Oh my God. So okay. Hi, Kat, Randall. This is. I would. Oh boy.
Everybody's mean to Twiz, like right off the rip. I don't know why. He's the nicest guy in the world. He'll sass you. But everybody's mean to him. They're so mean to him, Twiz. They blame Twiz for everything. Sorry, I had an earthquake.
Well, Twiz was sent the link hella early, and somehow said his phone was sitting right beside him, and he somehow managed to not see his special text. But anyways.
Well, Chelsea, if it makes you feel any better, he was on every show this week except for the one that his best boy billed him on, and he kind of, I guess he kind of gave me a maybe. It's my own fault for trusting him. Let's get him. Let's burn him. Burning's not good enough.
Well,
ain't good enough.
Was that from today, Kane?
What?
That you're saying he was supposed to come on, he didn't come on?
Well, he does. He never. Twiz kind of does what Twiz kind of wants. He's like your house, a cat.
Is that what they say about cats?
That's the common consensus. Yes, ma'am. Participants.
Thank you.
Participants were 189 criminal defense attorneys recruited via defense attorney lister serves New York, Tennessee, Wisconsin, Wyoming, Vermont, Idaho, Iowa, Arizona, Rhode Island. Note that some attorneys chose to leave some questions blank, and so we did not have our full sample of 189 attorneys. Participants completed the study online, and participants.
Kane, you missed the rest of the sentence.
Well, it was kind of implied. Attorneys for all questions, so the number of attorneys responding to each question is reported.
Right. Okay.
Participants completed the study online, and participation took around 10 minutes. Participants, it takes 10 minutes to sign up for anything. I'm not buying that. Participants were 50, plus they got to vet you. You're a lawyer. You're in the bar page. Participants were 57.6% male and 93% white. What is that? The remaining attorneys identified as Black, Asian, Native American, or mixed ethnicity. 33% of participants classified their political view as very liberal. What was that number?
33.
Why did they write out 33 and then 31?
That's
odd. 23% moderate, 11% as somewhat conservative, and only 2% as very. Is that true in the legal field that it's more liberal lawyer?
No, I don't think so. They're just saying for the sake of the study of the sample that they have.
They probably ran it in San Francisco. Our participants had practiced law for 13.52 years, I guess on average, and represented the prosecution in criminal cases 2.81% of the time. On their math, and then the defendant in criminal cases 80.43% of the time, 27.1%. Participants receive monetary compensation for their participation.
Okay.
Now, wait, I want to sidebar real quick, Chelsea.
Yes. Sure.
I think JJ brought up that there was no reward, or some. Maybe my guest Krista, that there was no reward ever offered in this case, and money is a big motivator, right? And I know
a reward to turn in Bryan Kohberger.
For information leading to the arrest of
yeah,
the
right. Yeah, I see
guilty
what you
party.
mean. Sorry, I was thinking. My brain was working on two different things. Right. Yes, I think you're right. There was never a reward offered. Yeah.
Well, one of the victim's family members even addressed it and said, "I understand you don't want a reward because you don't want posters all over town diminishing the attendance of your university. Believe it or not." And so that's, I don't know. I just wondered what your opinion was. All participants provided consent.
Hang on. Sorry, Kane. I wanted to say something real quick because back to what you were saying about like where was this taking place. So just to recap here, these different defense attorneys, okay, they're from New York, Tennessee, Wisconsin, Wyoming, Vermont, Idaho, Iowa, Arizona, and Rhode Island. So quite a diverse array of states here. Again,
That is
New York, Tennessee, Wisconsin, Wyoming, Vermont, Idaho, Iowa, Arizona, Rhode Island. Yeah. So there you go. Quite a mix. Okay, we were right.
It's not just San Francisco.
Right. That's good.
All participants provided consent to take part in the study, and the project was approved by Cornell Institutional Review Board. Participants were first asked whether they had any experience advising clients on whether to accept plea bargains and could select an answer of yes or no or prefer not to answer. They were asked a series of interview questions and finally completed an experimental task involving 2 hypothetical vignettes.
Okay.
Now, you really think that took 10 minutes? Come on.
That's what she said.
Interview questions. Participants were asked to respond to the following questions in the order that they appear below.
Oh, boy.
Have you read, seen, or heard? How often do innocent...
Kane, right, yeah. Read this. Jesus Christ.
How often do innocent defendants plead guilty? Interesting. Participants were asked whether they had been involved in a case where a client chose to plead guilty despite maintaining their innocence, and selected yes, no, or prefer not to answer, and whether they had ever advised a client who they believed was innocent to plead guilty and yes, no, or prefer not to answer. They were then asked to provide a rough estimate of what proportion of defendants who pled guilty they think are completely innocent or guilty. Now go back up, Chelsea.
Yeah.
What was the percentage of prosecutors as defense attorneys? I think it was much higher on the defense side, if I remember right.
Right, it was.
Right
Yes, that's correct. Yeah, only so. In other words, in of this sample, right? Because oftentimes we see people that are prosecutors and then defense attorneys. It's usually that way versus the other way around. But anyway, in this particular case, these are attorneys who had only been prosecutors basically 2.81% of the time. So these are basically your Bob Matas or in Attorney Chris, where I work, essentially where they've only ever been defense attorneys for the most part, right? 97.2% or something. So yeah, good question. Thank you, Kane.
Who are you calling a Bob Mata?
Well, Bob Mata is it's a rarity, right? When you've got an attorney that's only ever been a defense attorney, they're in the minority. So Bob Mata is just one example of one where he's only ever been a defense attorney. He'll say straight D.
So actually, this is a good pool to pull this particular survey from.
Yes.
Because it's people that would have to make that choice. Prosecutors are just like guilty.
Right. I mean, defense attorneys are definitely going to have an inclination to lean towards the defendant being either innocent or not guilty. And again, of the 2 attorneys that I work for, one of them was a former federal prosecutor, but the other one has only ever been a defense attorney. Again, that's a rarity. So, but they found a sampling here where only 2.81% had ever been a prosecutor. So that is, I think for the purpose of this, that's a good makeup to be drawing from. So I think we were about here, right, Kane?
No, we'd finished the paragraph.
No, we didn't.
We asked participants for a written response and told them they could just write NA if they felt unable to give a figure. When should innocent defendants plead guilty?
Oh, boy.
We asked participants whether there were cases in which they believed that innocent defendants should plead guilty, and if so, what the characteristics of these cases were, the role of attorneys.
Okay, hang on. Okay, let's not just breeze past this. So this is really important. And again, for anyone who missed it, the abstract of this entire thing that we're reading was really important because this is a big question, right? In terms of the role, like innocent. Okay, And what it's going to get into is this. It's going to get into cases where the defendant believes that they're innocent and cases where the defendant says they're innocent, but the attorney believes that they're innocent, right? And the role of basically of people that are innocent pleading guilty, right? And if so, when should they? And like I said before, this is a big dilemma because it wouldn't be fair to defendants who are actually innocent to not enjoy the same rights that those who are guilty have when there is a favorable plea deal on the table. And there are cases of that. We've talked a lot about it, right? There are some plea deals that are like really beneficial to the defendant. And it would be unfair to not give them that same opportunity. You guys see what I mean? That would be, just so like only if you're guilty do you get the benefit of, this great deal. Like that's messed up. However,
you hear a lot of plea deals where it's time served and you just basically take the stigma of the plea.
Or if you're Katie McBanoa, neither. You walk out and there is no stigma because the charges are all dropped completely and you have no record. Like again.
Yeah, that's a paid attorney.
Biggest mistake of all time there. But yeah, and then again, but the other problem being that on the flip side of that, you have this other issue of these coerced pleas from prosecutors. So it's like you've got some pleas that might be a really good deal and others that were like overcharged from the first place. And so there's a lot of elements here that are at play. And Twiz is asking how you hit your head, Kane.
I hit it on the door jamb it was because I parked my car a little bit to the right. I back in, and there's a little dirt patch from under where the cars usually is, and I had to step over it, and so I was fully extended, and I just whacked my head full steam on the roof, and it hurt. I was seeing double for a minute.
I will say you're doing well with the reading. So
I'm a good reader. I was a college reader in 3rd grade.
Okay.
Remember those little packets? Did you have those little reading packets in 3rd grade where they tested your reading? They asked you questions at the end of the paragraph or whatever. Anyway, I was remedial. Next, we asked participants, when should innocent defendants plead guilty? Next, we asked participants whether there were cases in which they believed that innocent defendants should plead guilty, and if so, what the characteristics of cases were. The role of attorneys. Participants were then asked probing attorney advice to clients.
Questions probing. Questions.
I skipped that word, sorry. It's my double vision. Participants were then asked questions probing attorney advice to clients. First, they were asked whether they have ever encouraged a client who wished to take a plea deal to go to the trial. Second, they were asked whether they have ever encouraged a client who wished to go to trial to take a plea deal.
Okay, pause real quick. So this is so funny because this is the same question I was asking of, I haven't had a chance to ask Chris yet, but ask Scott, one of the attorneys that I work for, right? Like, have you ever thought that it was advantageous to the client to take a case to trial versus a plea deal? So that's what this is really getting to. So first, these attorneys were asked whether they ever encouraged. So if the client wanted to take a plea deal, did these attorneys ever encourage them to go to trial instead? And then on the flip side, did they ever encourage a client who wanted to go to trial to take a plea deal? And I think also there's going to be, I'm sure, another section to this, which is if their client wishes whatever it is, if their client wishes to go to trial or if their client wishes to take a plea deal, should they ever be advising them anything other than what their client wishes in the first place? I mean, that's a whole other question, right? They're not even getting to that yet, right? But you see what I mean? Both of these have something in common. And what that thing in common is this, that they're encouraging their client to do something other than what their client wished. That doesn't give me a good feeling in my stomach. But that's one of the questions that's being asked here is the role of the attorney in the decision, right? Is it just they present the facts and here's the different things and you make your own decision? Or is it more like, poke, poke, nudge, nudge? Oy, it is a whole thing. Okay, and Kane, I'll read for a little bit so you can rest your noggin and eat your ice cream.
No, I'm fine. I just wanted to ask you a question. If you scroll back up just a smidge real quick.
Yes, a smidge. You got a smidge.
That's it right there. The characteristics of these cases. So would that allude to, were they pressured to make this plea? The characteristics?
Mm-hmm.
What are the various extemporaneous factors?
Right. I would imagine that probably what it's going to start with is sort of like how strong did they believe the evidence against their client was. but I don't know yet. It'll be interesting to see what the other characteristics are. Could be things like media exposure, right? High profile nature, things of that could, or maybe just how quote unquote, horrific the crime is. I mean, I don't know. They're probably all horrific, but having said that, this specific survey here isn't pertaining only to death penalty cases, so it could be lower level offenses. So I suppose that still could be relevant, right? Like if it was all death penalty cases, you could go ahead and assume that anyone would call it heinous, or even though I hate that freaking word, right? Whatever. The general public would view the crimes as being awful because if it's death penalty, it has to be murder, right? So, but it'll be interesting to see where they go with it, right? Like, are they going to include death penalty cases as well as things like, larceny, or like, I don't know, carrying a firearm without, concealed carry without a license, what I mean, like
Theft
whatever,
auto,
right? Like there's a whole
PD.
array, and it seems like they would probably have to try to limit it to a certain extent so that you could still compare the results, because obviously death penalty case and plea deals regarding that are going to be completely different than like, first degree burglary versus you take a plea to third degree burglary. You know what I mean? Like you just can't even compare it to.
I'm guessing that the most common, I don't want to say popular, but common case would probably be some type of domestic thing, and it's even in capital. It seems to be that in DUI, right?
For what now?
Well, I would probably say the top one would be domestic, including battery or assault, and then you'll have the second would probably be like a GTA or petite theft or something like that.
Top one of what? Top one of what now?
As far as most common felonies tried would be domestic situations.
Okay.
Really.
Well, but be careful with your wording, because if it's tried, there wasn't a plea, right? If it was pled to, there's no trial. Do you mean
sure,
charge?
but I'm saying the things that go to court most often.
Okay. I see what you're saying.
The most arrests, most common crime would be a domestic thing. Because I mean, it's either that or DUI.
Well, DUIs don't usually go to trial. Because a jury is going to be really likely to convict, and there's other reasons why DUIs don't usually go to trial. I mean, from what we read, I think there was actually a statistic about that earlier in what we were reading, that basically the higher the stakes, the more likely they will take it to trial, because it's sort of like, what do I have to lose? You know what I mean? Whereas with lower level offenses, especially if you're dealing with misdemeanors, but even if it's a felony, if you don't have a long rap sheet, I mean, were you there, Kane, the other night when we were looking at that example from there was a North Carolina case I gave you all an example of with a plea deal that was like absolutely incredible?
No.
Okay. Some of you guys in the chat might have been there. I think Twiz was there because it was during Twiz Reads, but like you would, that individual got the deal of a fucking lifetime. I would say Katie McBannon was in first place, Sarah Boone in second place, this particular dude, third place. Like, it was crazy. The deal that this dude got was absolutely incredible. And that makes me proud to be a North Carolinian, by the way, for that one particular thing, because the prosecutors gave that defendant a deal that benefited him more than it benefited the state, in my opinion. But it was all, I mean, but he had multiple counts of attempted murder, assault with a deadly weapon with intent to kill, which in North Carolina can also wind up with LWOP, just like murder. It can be just as bad.
You can get the life sentence for a speeding ticket in North Carolina.
I don't know about that.
I'm sorry, South Carolina.
I mean, I don't know about South Carolina, but he also had like multiple counts of conspiracy to murder. Like he had basically everything except for actual murder, like multiple counts. It was all of the things. It was crazy. And he was looking at and then they did all the things. They didn't just drop a bazillion charges, and he was left with like the two least severe charges of all of them. But not only that, they also completely took a sledgehammer and a machete to the sentencing guidelines and completely smashed that shit. It was wild. Totally worth watching if you missed it. And it is timestamped. I think I timestamped it. It's from the last live stream, and it says North Carolina.
I was watching the show and everything. I think I fell asleep.
That's okay.
But
basically, you can see how they really had all this room, especially because there were so many charges. But like, I don't know, the defendant came out on top on that one, which I'm proud of.
well, I mean, it's kind of sad for the victims.
Yeah. Now, having said that, I have firsthand experience that they do consult the victims with this, because I had an example of this the other day firsthand, where I got an actual email from like whoever it was, the ADA, or I don't remember if it was federal, but like literally there was a deal that was offered for one of the clients, and like before saying anything about the deal at all, nothing at all about the deal, they were like, we have to go speak with the victims first. And I was like, well, there you go. So the victims must have been fine with it. I think this defendant was headed to trial, and maybe they wanted to, maybe they wanted to skip having to go through a trial. I mean, who knows? But what I will say is, at least so far in my experience, North Carolina, unlike other places, they do actually consult with and discuss and confer with the victims, because I will say this particular email came in probably a week or two ago, and I've not heard back yet, which means they're still talking to the victims. It's not just an overnight thing. They're still talking. And actually, it's one victim, actually. It's one living victim, and they're still talking with that victim, because they've not responded at all to the deal, the offer. So yeah, I mean, and actually we've got a number of cases right now that are pending acceptance of a plea deal. And with all of them, I will say I was there when the plea offers were made or whatever, and none of them have actually resolved with the plea yet. Like, they're all still pending. So I'm happy about that. Like, the one thing I can say so far in my experience about North Carolina is apparently the public defenders here, at least in Forsyth County, are no bueno. But everything else so far seems to be above board, and the prosecutors aren't being completely insane. And anyway, just things are, I'm happy to see how, because, seeing how the system is being managed and how it's going. And the prosecutors are really willing to discuss and work things out with defense attorneys. Like, there's a lot of conversation back and forth, which I see it firsthand because I'm CC'd on everything. Like, literally, they'll just like call up and chat and like talk about it. And like, it's really a good thing to see. Like, there's a lot of cooperation. So I could go on about it.
I was gonna ask you that behind the scenes, it's just people talking, and they don't.
Yep.
I mean, other than the reputation and the monetary aspect, they don't have any skin in the game like the defendants do. So they're just like, yeah, should we give this guy this? What do you want to do? Let's play golf at 3:30.
Yeah, I mean, I've literally seen emails like from these attorneys to like the DAs, or or sometimes it might even be the U.S. attorneys general. It's like, come on, like, you and I both know, like, this is a little bit much, and and they literally just talk to them like people. It's not, it's kind of like that as a predecessor before you see like a formal arrangement where it's like legalese. There's these emails going back and forth where it's like LOL, like type of stuff, right? It's like the way normal people talk to each other. And the thing is it helps too when you have a long history and having built up, what's the word? Like, good rapport, right? Like, these attorneys have a lot of rapport, and you can see that how much that helps. Like, I just picture like a brand new defense attorney into the area. It probably wouldn't go so well for them, but because they have a reputation and a rapport with these different prosecutors, and again, even like the federal U.S. attorneys, their reputation, and that's why we see
it holds a lot of sway. It really does. It's huge.
Exactly, because
judges will literally bow down to some attorneys.
Because these defense attorneys, when they're like, I staked my reputation on this, they mean it. And you take them, that's that ethical, that's where the ethics come in, right? Like, they're not going to bullshit you. And so when they say that, people listen. And the thing is like, that's part of why, if you're a defendant, like, I just am so proud, like, because I know, like, if you come and you're with Chris or with Scott here at the law firm where I'm working, you are getting the type of representation that you deserve, 100%, point blank. It is what you want to see in the justice system. It's a beautiful thing to see. I could go on and on. I already have gone on and on. But also, Meg's here, yay! And also, welcome to Miss Pottage.
And Miss Pottage is here also.
Love it. Welcome, guys. We've got a little bit of a change of quizzery. We've got Kane on tonight. Kane reads. So everybody, please
Yay.
Show your love for Kane, even though he has a head injury, maybe. He's still here reading for us. Thank you, Kane. Thank you.
If you put my name up there, we'll probably get a few more people in this. I'm just saying.
Put your name
I'm
up
kind of
there.
a big deal. We scrolled up. If you remember, you got to scroll down a paragraph. Please just.
Okay. I may have already. Let's see here. Okay, I think we're here.
We're at participants. Yeah, experimental task, assessing attorney advice. Participants were given 2 hypothetical plea vignettes and were asked to decide whether a client should go to trial or plead guilty in the vignettes. Case 1, involved a young girl who had been caught with Mary Jane, and the other, case 2, involved an adult who was accused of SA. The specific vignettes presented to attorneys are included in the appendix.
Oh boy. Should we go and find those? Do we want to see the specific vignettes?
I don't know what a vignette is other than a blurred edge.
So I think what they're saying, it's like a brief narrative, right? Because these are hypothetical situations.
Yeah, okay.
So they're going to give. So in other words, there's going to be some facts of the case, but it's going to be brief. In order for the defense attorneys to weigh in on it, right? So you've got the young girl who'd been caught with Mary Jane, as you said, and the other was an adult who was accused of SA.
The devil's lettuce.
Right. Yes. Let's keep reading. If it seems like it might be valuable, we can go find those in the appendix.
Yeah, hopefully it's at the bottom of the paragraph or something, maybe. Case 1, case 2. In both cases, the defendant claims that they are innocent and must choose to plead guilty in exchange for a misdemeanor conviction or go to trial and risk getting convicted of a felony. We randomly assigned half the participants to additional facts in the hypotheticals, which meant that pleading guilty even to the misdemeanor would have particularly harmful consequences for the client. Likely rejection of citizenship application in the plot case or the loss of a career as a teacher in the SA case.
Okay, so one important thing to note. Hold on, sorry. I just want to point something out. So what they're saying is only half of the participants, right? This is where it gets sciencey. They randomly assigned half of the participants to see these additional facts. So in other words, these facts that they're saying are additional, that only half of the attorneys saw, are facts that, as you can see, give more serious consequences, right? More harmful consequences for the client. Half of the attorneys got to see those and half didn't. Okay.
I'm back. Okay, hold on.
Yes, you're back.
Participants would either see both cases with these additional consequences or neither case with these additional consequences. We included this case.
So sorry, I don't mean to interrupt you. I just want to point out what they mean by that, because the wording's a bit weird. What they mean is the participants wouldn't see the additional facts of only one and not the other, right? They're only going to get the additional facts for both of the hypotheticals or neither. Okay.
We included this case to mirror scenarios such as that in the Lee case, where even a misdemeanor conviction would have severe consequences, to see whether this would discourage attorneys from advising a client to plead guilty, especially where they suspected they were innocent.
Okay.
In each case, we asked participants to estimate the percentage likelihood of the defendant being guilty and the percentage likelihood of the defendant being found guilty at trial. The order of these questions was counterbalanced when they asked them what they would advise the defendant to do in the hypothetical and asked them to give a short justification for the response. We used these answers to examine the relationships between probability of conviction at a trial, guilt and innocence, and plea advice in a real task.
Okay, okay, good. Let's break this down real quick. So here's what this is asking them, right? They asked these attorneys to estimate the percentage likelihood of the defendant being guilty, and then this would be separate, the percentage likelihood of them being found guilty at trial. So there's a different set of questions. It's like, are they actually guilty based on the facts they're presented with, or do they think they will be found guilty at trial? And then they also asked them what they would advise the defendant to do in the hypothetical, and then give a short justification for their response of what they would advise them to do.
Wow.
And then they use the answers to examine the relationships, probability of conviction at trial, guilt or innocence, and the plea advice.
So this has direct relevance to Latah County because
100%.
his chances of getting a guilty conviction were very, very high in Idaho.
That's right. That's right. So these relationships matter, right? That's why we're doing this, because the probability of conviction at trial, actual guilt and innocence, and then the plea advice. Because the plea advice, that's what's going to be so interesting, right? Because the plea advice can vary, right? As we saw in the very beginning of this, you could have times where the defendant is like, I don't think it's the best idea to go to trial. And the defendant is like, nah, go to trial. Or sorry, the attorney's like, nah, go to trial, and vice versa. Right. And that's when I was like, oh, that makes me a bit nauseous, because I feel like they shouldn't be advising other than what the defendant wants. But again, that was one of the other considerations, because in this study, what they found was the attorneys all differed in terms of how much the role of the attorney, how much role they should have. Should they really advise them? Should they really direct them and give them advice? Or should they just simply present them with their options and let the defendant choose? And it's a really big ethical question. And honestly, it goes right to the heart of what we're being presented with as we discuss the pros and cons of the plea deal. And especially when you really trust, again, look at Katie McBanowa, okay, as this is the cautionary tale, because she had expressed that she wanted to take the plea and there was no reason not to. It is insane. But she really wanted to do what her attorney wanted. And it was the type of thing where it seems like she didn't want to disappoint her attorney, which her attorney was like, nah, go to trial. Like, what the actual dude? And so I think I just straight up malpractice. Like, I don't even get me started. So, if they really, now I'm not saying that every time a defendant pleads, that's what the case is, right? Obviously. But what I'm saying is you can see why the question of how much role should the attorney have in helping to advise the client of what they think is best for the client, like that it really is a big issue, perhaps more so with like anything else, right? Because like you most of the time, right, as we know, for example, the defendant taking the stand, we hear this all the time in these colloquies, right? The defense attorneys are going to sort of let them know what their rights are, but we know they're not going to tell them definitively, you should or shouldn't take the stand. It's going to be left to the client. Now, the client might read between the lines or what have you, but they're not going to really, like, for example, if the client's like, I don't want to take the stand, they're not going to be like, no, you have to, or you know what I mean? Or vice versa. That's why the plea deal is really in a small, it stands alone, in my view, of a situation where it's really in a category all by itself, of where the role of the defense attorney is maybe a little bit less obvious. It's more murky. Obviously, like we've already read here, the different defense attorneys, even amongst themselves, disagree on the role that they should have. And then you have this whole other ethical issue of like, well, if they're actually innocent and if the attorney thinks they're innocent, advising them to plead guilty. So there's a lot of elements here that honestly don't pertain to like anything else that we see when it comes to the attorney-client relationship. And there's a lot of ethical considerations and a lot of legal considerations and a lot of, which is why I love it, there's a lot of like sort of philosophical considerations as well when you combine it all together. And so I think it's a really interesting thought exercise, but I think it's also a question that this is very practical, right? Like this in reality is a big deal, and it actually has huge implications in reality, like today, tomorrow, the next day. You know what I mean? In addition to being kind of like a philosophical exercise. So any thoughts on that, Kane?
Well, it on a side note, it makes me realize, and I want to get your opinion on this, is unethically, it does appear through the withholding of discovery, etc., the prosecution has pressured the defense into this plea deal, allegedly, possibly. In this, looking at it from this angle, would it be something that could be possibly investigated and reviewed in the future? Or because it does seem that they well crossed the line in many instances here, which left the defendant no choice other than to take life over death.
Right. Are you referencing especially the latest docs that just came out?
Maybe. I don't, just as in a whole, really, whatever my double vision is telling me to do.
So, it's interesting because The problem being that, you know, this entire time, right, Ann Taylor has fought tooth and nail with these issues, right, with the discovery issue and to get discovery. And it's one of the things that I mentioned when right before the plea hearing, when we pulled up and we looked at the forms for Idaho with the plea, the colloquy.
Yeah,
right?
that was good because people are like, why is he asking him if he's drunk or on drugs and if they were human? It's like, well, it's in the documents. That's
Right.
You know, we'd already been through it thoroughly, so I was like, these are no surprises here.
Well, one of the things
He's
that I
not making it
noted
up.
when we went over it, one of the things that I noted was there was a question there on the form. Again, we went over this like maybe 2 days prior to the plea hearing. There was a question there that was like, have you had enough time to go through all of your discovery or what have you, something along those lines. And I literally stopped, and I'm sure it's timestamped. And I was like, oh my God. I said, if anything at all, I could see there being a pause, and I could see Bryan Kohberger saying, no, I haven't, right? Because literally right before this happened, there was still outstanding requests for discovery. Now, having said that, I didn't realize that same question was going to be asked of Ann Taylor. And literally when we were watching the plea hearing itself, I was shocked. Like when it got to the moment where he asks that question before he asks Bryan, he asks Ann Taylor, have you had plenty of time, I'm paraphrasing, right, to review all the discovery or all the evidence in this case, what have you? And there's a pause. And then she goes, yes. And I was like, oh, because I was like, what? I was very surprised that she said that. So one of the things I will note is the fact that she said that, and then also he said that. That's part of the issue here, right? Is that that's the colloquy matters because you're waiving like almost all of your fucking rights, right? When you take this plea deal. And so if you want to preserve, if there's any of these issues outstanding, I mean, I was really shocked by that. I was like really actually shocked. I was like, really? Because like up until this hearing, they were still fighting and, motion to continue and all the rest, right?
It was a pause for the cause, Chelsea.
Right?
So it was a pause for the cause to get to the goal. You gotta lie a little bit, just like Bill did with about the ways they got to him. So.
Maybe. And you know what? That just is another really interesting question, King, because I literally thought that same thing. And it's like that honestly needs to be in the mix of this entire consideration that we're reading about, right? And I don't know that they bring that up because like that's a whole other category, right? Like this whole other, it's a great question. Is it ethical for the defense attorney and the client, right, to really essentially lie under oath? I mean, you see why this is so problematic.
No, while we're on the topic, I have a little caveat for it.
Go ahead.
As far, oh shit, my brain just broke. I'm sorry. Kids go to bed. What was it? Forgot. Say what you were saying again. Words.
That like it adds a whole other element in terms of all these different questions that we're asking, which is like normally you can't lie under oath, right? We know this, right? Especially if you're the attorney, but no one, anyways. So
I'm sorry, I just remembered the caveat. Let me interrupt you. Shit, now I forgot again. Say what was the last sentence you just said? Everybody with me. I did hit my head really hard.
So the issue of in open court and under oath, right? The attorney and the defendant basically lying under oath to say, yes, we've had enough time to do all the things.
No, that wasn't it.
Mittens for King says, please go to urgent care.
Words.
Well, I was saying it adds a whole other element to all these other questions that are already being asked, which is this notion of
the S1,
okay.
The one thing that they're withholding the most, and it turns out it's the grand jury testimony. And that is one of the pieces of discovery that either they won't make public or they won't even turn over to the defense. And that seems to be where the answers lie in this case. The grand jury testimony.
I would be surprised because grand jury testimony just very rarely comes out. But what was interesting, we covered these new motions or new filings at the beginning of the stream. But what was interesting is that normally when we get these motions for things to be sealed, we don't get a reason. But here we got a reason. It says this motion is made on the grounds that the substance of Exhibit 1 contains information that would constitute an unwarranted invasion of personal privacy for the named individual that is the subject of each discovery request. And it's 4 items. So 441, 442, 443, 40. So 4 items of discovery request, but 1 individual for the named individual. So
why do they get their rights protected so much?
Well, and I said this earlier, this could be Bryan Kohberger. We don't know. Because remember, if you're a defense, you want discovery that pertains to your client too, not just other people. You also want discovery. If they've got something else on your client, you want that too. It could be him or it could be someone else. But they're giving a reason here when normally we don't get this. Normally we just get pursuant to the rule, sealed, right? This was interesting bit of information that they say constitutes an unwarranted, like they're actually giving a reason. We never get this in these filings where they make a motion to seal. And we usually don't get a number of items either, I feel like. Just as a side note, the Exhibit S1, I have said this earlier, is just a running joke to me because literally every exhibit is Exhibit S1. Like, I've been saying this for months and months and months. I'm like, oh my God, how are they ever going to go to trial when everything is labeled S1? Literally, like everything is
literally, it feels now
S2, but like everything else is S1.
Yeah, I mean, it just feels now like everything was decided 2 years ago. As far as the information they were going to give the public, the outcome, is it weird that the prosecution is so have the blinders on to any other stuff that comes out other than what they've obtained and what they've decided on within this case?
I mean, I do
this
think
particular defendant.
I do think it's weird, but I will just say for the record that the weirdest thing of all of it potentially is this Exhibit S1 thing. I've never seen this. This blows my mind that literally everything, because Heather even agreed. She was like, everything is S1. Yeah, it is, because how are you supposed to go to trial when everything's labeled the same? Disaster. Like literally the normal course of practice would be S1, S2, S3, S4. Think about every trial y'all have ever watched, or even if it's just hearings or whatever, even in hearings when they reference evidence, they go either through a bazillion letters of the alphabet or the letters stay the same for like S for state or D for defense, and the numbers go up, right. A great example, one that just is etched into my brain, Exhibit 313. That's from the Casey Anthony trial, but it's Exhibit 313 because it was the 313th exhibit in the case. And like you number, like this is every single thing was S1. I think there was maybe one S2, maybe just as a joke, but like everything was S1. And it's like, what the heck? But I pointed this out months and months and months ago. And I was like, hang on. Because at first I thought I was the one who was confused. Because I was like, wait a second, we just did S1. And I was like, oh no, they're all labeled S1. What is happening? So I don't understand that at all. I've never seen anything like that. I mean, that doesn't make any sense at all.
That was a great answer, though.
What was?
A pretty thorough answer. More than I knew when I started reading today.
Oh, well, good. I'm glad. It is straight up inexplicable. Yeah, it totally is. It's absolutely craziness. I mean, really, I will just say, don't, take this however you want. But, I mean, in a case that's postured towards trial, this would be like, okay, let me give an example. Let me give an analogy. This would be like, okay, in a case that's postured towards trial, the analogy would be you're going to do like a triathlon, but beforehand, you're going to shoot off your arms, your legs, your eyeballs, your ears, and like partially decapitate yourself and then try to go do it. Does that make any type of sense? Is that a good analogy? Like
it is, because it with what they've done to her, she got to the point where I can't defend this case. I just, A, I don't have the material, and B, I don't have the resources, and C, I don't have the time.
Well, I don't disagree, but I was referencing specifically to Exhibit S1, that naming everything Exhibit S1. If you're posturing
that being the foremost reason,
and you label everything S1, you're fucking yourself before trial. Like, what are you like? If you're headed towards trial and you name all, because again, the prosecution is the one who's choosing to call it this. If you're postured towards trial and you're calling all of your exhibits the same name, do you see? Like, it's worse than the example I gave. To be honest, it's like, what are you doing? Like, beyond masochistic. because you're going to get to trial if you're headed towards trial, which you're supposed to be postured towards, and you're going to be completely fucked up, down, diagonally, all the ways. I can't even give an analogy good enough to say what you would be have done to yourself. I think Heather probably knows what I'm saying. Because you've just now made it impossible to go to trial. Like, what am I looking for? Oh, Exhibit S1. Oh, sure. Which of the 50 million S1s are you referencing?
That's crazy.
There's no way. How do you?
Yeah, I mean, that just makes it seem more and more like they never plan on going to trial.
And that's why I brought it up. Because if you're postured towards trial, labeling your exhibits like this makes no sense. Even if you're not postured towards trial, why not just count? Do they not know any number besides the number 1?
It is Idaho.
You just go 1, 2, 3, 4. Not that hard.
Do you think it's true that there's a chance they might transfer him to an Arizona prison, or is that just wild conjecture?
I've not heard that. I don't know how. What do you mean? Like after sentence?
I don't know. People say all kinds of things, but I think they're kind of referring to Skybell or Daybell or whatever.
Yeah, I was going to say, maybe people are getting their wires crossed just because of the
people. I mean, can you blame them? Look what they put us through with this.
Well, yeah,
everybody's wires are crossed right now.
That's a fair point. And to the other thing I was going to say is this too, because we talked about this before, right? Remember how we mentioned that the state has an ongoing duty to turn over discovery after the plea but before sentencing? Literally, that was so funny when I read this here. However, in accordance with Idaho criminal rule, the state has a continuing obligation to provide discovery. Y'all heard me say this if y'all were here. I think we first talked about this. Well, when there was first whiffs or notice of a plea deal, and we went through the whole thing with all the forms, we talked about this, right? How they have a duty to continue to provide discovery up until sentencing. And so, but it's really interesting that this is happening. And the other thing I said this earlier at the beginning of the live stream, I'll just real quick. The thing that surprises me is that they didn't wait until the eve of trial to plead, because like I was saying this before, and I apologize to anyone who heard this earlier, but it won't take long, but it's important to say that normally in cases, right, you're going to have people plead early on, right? Or you're going to have people plead like literally on the eve of trial, as in the day before trial. And Flash gave a great example of a case where somebody pled like 15 minutes before opening statements. But that is not uncommon. I've heard of lots of cases like that. And in fact, even for the law firm where I'm working, there's so many times where we've got these defendants and it's the day before trial, and that's when they plead. That is more common, either pleading early or pleading like the day before trial. So the thing that is interesting to me is that they didn't wait. That's my question. Is if they're going to do it, why didn't they wait? Especially when there's more discovery coming in. Like that's the thing that, and honestly, when that plea first came out, even I wasn't even thinking about the discovery, but the question, everybody's like, oh, why did they wait so long? My question was, why didn't they wait longer? That's the part that was surprising to me, because why now? Like, this is the weird one where it's like, what, 2 months or whatever, 1 month before trial, but like, you don't ever hear of that. It's usually early on or like the day before trial. And that's the thing that is weird to me. And then on top of that, you have a return on this request for discovery. There's no and let me put it this way. There's no incentive and no reason for the defense to have taken a plea deal now versus waiting. There's no reason. There's no benefit to them, right? Normally they wait until the day before. So any thoughts on that, Kane?
I think we circle back to my original question. Is the discovery that they release and say the gag order is lifted, will the releasing of the gag order mean that these withheld documents and such get released to the public, or only to the attorneys involved?
Okay, but what you're saying, so releasing the gag order though would only have been and has only been in discussion since the plea deal, right? So if the question is why would he be pleading now versus later, if he'd waited to plead until the day before, which is the more common thing that you'll see people do,
yeah,
the releasing of the gag order wouldn't even be in discussion. That's only in discussion because of the plea, right? So in other words, it still would have been this whole thing. We got the gag order in place, no leaks, and that would have continued up until, for example, hypothetically, the day before trial, if he had pled then, right?
Yes.
That makes sense.
Well, I used phone a friend, Chelsea, and then my 50-50, and I say that him doing the plea deal this far in advance of the trial lends credence to the theory that something big came about or something happened that we don't know about.
I want to say too, because I've been saying this all along, and Heather is also saying it, because we all oftentimes think like, yeah, just to reiterate, there's a differentiation, right? The gag order and the sealed docs are two completely different things too. So let's just make sure that that's clear for everybody. Because just because the gag order or the non-dissemination order is lifted, that doesn't mean anything about the sealed docs. Remember, the non-dissemination order is just simply speaking to the media. So, and I've said this before, and I'll say it again. I care less about that, and I care more about the docs, right? I don't give it, like, people talking to the media, like, honestly, you guys know how I feel. It's like, give me the docs, right? So that has no bearing on, like, and I've heard a lot of people, even people on YouTube that are like bigger channels and what have you, seem to be getting them confused or conflated, like as if the lifting of the gag order means we get all the docs, or they just sort of like aren't really thinking about it all that hard type of thing. But it's important to keep that in mind. And so thank you for reminding me of that, Heather, that there's been no talk of when the docs will be unsealed. We have no idea. That is not in a discussion. The gag order is just simply, can the parties involved speak to the media? Which, I mean, in my opinion, could only just fuel rumors and whatever, misinfo, give me the docs. Give me the docs any day, but that's just me. So
is it typical in these type of capital cases for them to release crime scene photos,
No.
not necessarily bodies?
Oh,
So
well, okay. It depends. So, there's countless other cases we could use as example of what is released for the crime scene. And really it's like, Murdoch, just an example, or I probably have those photos handy, but whatever. Like they're not going to show the bodies, right? Or if they need to show a picture where the bodies are located, the bodies will be like blurred out so you can see where they're located, but you can't see the actual victims. Those should be released. But if it's photos of the crime scene where it's like even with the bodies blurred out or whatever, it's like too much. You know what I mean? Like
but the thing is, Chelsea, even in the most sensitive cases of all time, like the Vegas shooter or Columbine, eventually the actual crime scene photos with bodies and everything, at least of Klebold and the other guy, were somehow released to the public. I think as time goes by, the consequences for that kind of thing is just brushed to the side.
I think they must have been leaked, because in every case that I've ever heard of, crime scene photos that show the victims are supposed to be permanently sealed. So those must have been leaked. That's not correct. Yeah, that we there's no reason the public. Yeah, no, that's not something that people should.
Maybe it's just because of the world we live in now, the electronic world, and because like I said, those. Can you think of a more sensitive case?
I know, right?
And that's still, and even the crime scene photos, even before the trial was done with the Delphi hearing.
I was literally thinking the same thing. Yeah, and that was a horrible tragedy, that whole thing, right? With that.
I mean, that's something nobody wants to see. Right,
I know. When there's crime scene photos that are out in the public that involve the victims, those are due to leaks. I've never heard of any time where those are released, even when it's something that's not as graphic, right? Like there's certain.
Well, I mean, going back to the Manson case, those photos appear in books like it's nobody's business,
Well, and I don't know much. Flash can speak to that. He's like an expert on that case. I wouldn't be surprised, and I don't know much about that case as much as others, especially Flash. But that was what, the 70s, right?
It was 60s.
Yeah, it could be too that it was different back then in terms of I don't know. I don't know enough about the case, though. I don't know what types of. To be honest with you, I don't know what types.
I think it was 69, actually. Yep. Okay. There's
Flash is an expert at this case.
It was like June 69 something. Tate LaBianca murders.
Travis Alexander. Were those leaked or were those released by the court, Meg?
I'm not sure. I just I had a buddy who was studying to be a lawyer in high school, and he had the little softback paperback books or whatever, and they had the crime scene photos. And in particular, the reason I ask you, Chelsea, is because even if it's not just the bodies, you wonder if there was something written on the walls or something along these lines, a message.
Right. Yeah, that's a great point. Yeah, I mean, those should be released. To be honest with you, Kane, it would be weird if they're not, because in every case that I know of, they're going to release everything that they can that isn't going to be horrendous for the victims' families, going forward. As long as it's, again, even if the body would be there, but they can blur it out, that
right. Well, in this case, they went as far as removing pieces of drywall from the house before they even took down the house.
Right.
Which makes you think that there was something to that, whatever it is.
Yeah, I mean, I would imagine it's to test it, because we know that they will do that. They will remove pieces of wall or pieces of floor, so that they don't disturb the sample of whatever the thing is. But it could also be something written. That's totally possible too. I mean, yeah, these are all good questions, though. I appreciate these questions, Kane, and everyone in the chat too. For those,
I can keep reading. So I'm sorry if I got sidebarred.
No, don't be. This is what we do here. We love these side tangents, and I think it's an important discussion, and these are great questions. I do think that, like, if there are not photos of the crime scene released that are, like I said, go by the normal standard, it will be very weird if we don't see those. However, considering so much of this case being sealed, like, that would be expected, but I can't say that that's the right thing. Now, having said that, when things start to be unsealed, which they should be, that should happen, right? At some point, that needs to happen, or there's going to be big problems. I would also expect there to be some photos of the crime scenes. Again, nothing that shows the bodies, right? But, like, or sometimes it might be where they can show a part of the body. I mean, we see this in other cases where it's like you see the leg, but not the head. It just depends on where the injuries are. The example I gave the other day, I think, is a pretty good example. Take John O'Keefe, right? In trial, they did not show the public or the gallery or anything pictures of the head, but we saw millions of pictures of the arm, right? We saw lots of pictures of the arm, because those injuries were really important in determining what happened, but they were deemed to be not so, how would you describe it, Kane?
Graphic,
yeah. So you know what I mean? So there's a difference.
Offensive or horrible.
Right. Or yeah, right. Exactly. So you could, you look at those arm injuries and it's not over the top, right? It looks like it's got scraped or what have you. But you obviously bit by a dog, but in other words, people get injured like that, right? And don't die. And anyways, but the head injuries on a different level. And that was sort of a determination made, by the powers that be. Did someone else click on the link to the live stream?
Oh no, I put a share if you want to play it real quick there for you.
Oh, sure. Let's take a look. I see Jeff. Oh my God.
The detectives showed up at my door to investigate me, and they were breathing down my throat to try to find out if, I was some psycho cult leader brainwashing people. Big scary Jeff and Shalia. Ah! We're gonna come and eat your children.
Keely also has
That was all.
Dude, Kane, I saw that earlier. I don't know that you saw me in the chat. I was like leaving
Yeah, I
work.
saw your comment.
I love that you added that to your like intro and outro. That makes me so happy. Oh my God, it's so good. I know many of you guys also appreciate that. It was awesome.
It was a little surprise for me, a little treat.
It was great. I
for
loved
the few
it.
that got it.
I'm so glad I caught it too. Because I just happened to get done with work a little bit earlier, and so I literally got to see that like at the
Yeah, that's why I was so happy to see that you were in chat.
Yeah, that was awesome.
I was like, perfect.
So yeah, so let's see here. So there was, the new filings. Okay, so back to this. Where were we? All right, cool. So that was awesome. I love the questions. I love the comments. I love the discussion. That's what we enjoy here. So okay, here's scenarios. Right, I think we had just finished with this. Yes, that's right. This is where we left off. Okay, you want to keep reading, Kane?
Sure.
All right.
Following completion of all tasks, attorneys completed some short demographic questions asking about gender, political orientation, and years in legal practice. The results: 166 participants answered our questions about experiences with the plea bargaining system. Oh, so it's a system.
The plea bargaining system, yes.
So they call it a system.
Oh, yeah.
So it's just cogs in a machine. One of these 166 participants, 163, or sorry, of these 160 participants, 98.19%, 95% CI, 94.82%, 99.38%. Is that a formula there?
Good question.
It's like a first in, first out, first last, whatever. Foil.
What they tell us what CI meant? I don't remember seeing that. Let me see if that's a good question. Let's see if we can figure out what that means.
I'm like straight using algebra in law, man. That's why I couldn't do it all.
Oh, you should have seen the stuff you were looking at earlier. Oh my god, it was so mathy. I was like, what?
Yeah, I was looking at those. I'm like,
were you there for that?
Is this the purge?
I don't know. Do they tell us? Do they not tell us what that means?
It's confidential informant.
Oh my god, are we just supposed to know what that means? We might be able to figure it out. I don't know.
Coveted inventory, Schindler's List.
Where did the
Oh wait, there you passed. You just passed the formulas, right? A little bit right there. You start. It has SD, SD, SD. I don't see CI.
Yeah, me neither.
No, maybe it's in the vignette.
Maybe. Oh, case. I bet
case.
One, maybe. I bet that's what that is. I bet
is
that's
it a
Roman
one?
numeral.
And I read it. No, it's a CI. So case
Yeah,
investigation.
but in law, they could be using Roman numeral 1. They could
case interval. Maybe yeah.
There you go. Case interval. That could be. That sounds right.
Even a broken clock's right twice a day. Just.
Oh my god.
That doesn't mean it works. Stated that they had experience advising clients on whether to accept plea bargains. One stated that they did not have experience advising clients on whether to accept plea bargains. Numbers, math, 0.1%, 0.3, 0.3%. And two said they preferred not to answer. 1.2%, 95% crime scene investigator.
So let's read this another way. So of these 166 participants, 163 said they had experience advising clients on whether to accept plea bargains. One said they did not have experience, and two said they preferred not to answer. So there you go. Gotcha. I guess those are just the maths of it all.
You dumbed it down good. I'm as dry as a chip. I need some more Jergens, Mama. I'm dry as a chip.
What?
It sounded funner when she said it. It was a Kentucky girl was talking about her South Carolina roommate, and she was real close with her mom, and she would call her mama, Mama, I need more Jergens. I'm dry as a chip.
Oh Lord.
Okay,
but guys, here's what I'm going to say though. We're going to continue with this on part 5. I'm leaving you all with a cliffhanger. How often do innocent defendants plead guilty? That's the question. So that will be the theme for the next one. And the reason being because I've got to get some stuff done for some of my students. And I also have something I got to do for work as well. But Kane, thank you so much for being here. And Twiz,
you're welcome.
Tisk tisk to you, Twiz. I'm just kidding.
Thank you for the great answers, Chelsea. Good night, chat. I'll see you in the chat.
So Kane's going to see y'all in the chat. We're glad I can say with 100% confidence that Kane, I think his head is okay. I feel like I would have been able to tell if he were suffering a type of concussion. So we're all very glad that Kane's head is okay. So yes, come for facts and leave with a twice-a-day clock quote. That's right. That's why y'all come here, right? Also, Meg, I'm happy to see you because you were saying earlier in Kane's chat that you feel like you've missed me. I've missed you. We've missed you. We've all missed each other. Reunited and it feels so good. Twiz reads later tonight. I don't know what Twiz, is this a question? I don't know what Twiz. Are you saying you want, first of all, in advance notice and then also your special text? Y'all, I sent you your special text like as I was going live. I thought that was really good. I mean, besides that, though, you've had like a solid couple hours, though, to where you could have arranged yourself. In other words, enough time has elapsed that would probably be even more time than you would get on a heads up, because with me getting home from work late and whatnot, sometimes I don't even have my own exact time that when I'm going to start. So I'm oftentimes like scheduling it for an hour or half an hour from whatever time it is. Anyways, these just sound like excuses to me. Just kidding. They're not kidding. You wouldn't have been able to come on. So you're saying you wouldn't have been able to come on because it was so hot today. Okay, well, tomorrow, Twiz, I'm going to give you a heads up now. I don't know exactly what time, but it's somewhere in the 9 o'clock vicinity. We will go live with part 5. Go live with part 5. Yeah. Sorry, I'm so nerdy. And we're going to carry on with these interview questions, guys, and we're going to find out the answer. And we do still have some more left with this other document that we can go over as well. We were on page 58 to 79. So we might finish this as well. And if I can drum anything else up, we will go over that too. So we will, Meg, don't be looking ahead now. And also the final answer is not simple anyway, because there's a lot of different factors to this. It's not so simple. They're going to break it down into subsections. So anywho's. And also they're going to talk about why and the circumstances and what they believe. So Mittens for Kittens is happy that Kane is okay. I'm also glad that Kane is okay. Thank you so much, Rat Daddy, for being on here and being our Rat Daddy Reads. That has a nice ring to it, doesn't it? Rat Daddy Reads. Okay, well, that's good, Twiz. Good. We're happy to hear that. But yeah, thanks so much, everybody, for being here. Love you guys. I love this discussion. I think that this is really important. And I'm really glad that we can really take a good hard look at just the structures in place for this, right? And the systems in place. And the what the law says and what, I just think this is really important. These live streams, as I've said, have been a long time coming. I've talked about, if y'all were to even like go way back to like my very first videos and whatnot, where I'm actually talking, I'm sure you don't have to look far or watch for very long to hear me talking about, I need to do a whole live stream on the plea deal, And anyways, I'm just happy that you guys are here to discuss this with me, and that y'all are hanging in there, even though it's a lot of reading and a lot of numbers and a lot of letters and whatnot. So I appreciate that, guys. Classic Flash. I'm going to bed or to eat chicken, whichever comes first. Classic. Love it. I hope the chicken is what ends up happening for you. But y'all, I love you guys. Thanks again to Kane, Twiz. We love you. Hopefully you'll be able to come on tomorrow for Twiz Reads. I appreciate everybody who's in the chat and anyone who's on Replay Crew. We love you guys. Y'all are the best. But for now, it's time to squirrel out. Squirrel out.